Thank you, Worship. The State versus Julius Malema, case number Regional Court 44620B. The date is the 23rd of January 2026. The parties are as follows. Presiding Officer Mr. Steve Olivier, Public Prosecutor Advocate J. Caesar. For the defense is Advocate L. Houders, SC, instructed by Ian Levitt, attorneys. Interpreter is Ms. Murray and the clerk is Ms. Mdantsane. Your Worship, this matter has been set down today for the sentencing proceeding of the accused. Your Worship, I also just want to put on record that I have received a pre-sentence report this morning at 8:45 from counsel for accused number 1, and that I would, in all probabilities, need time to go through such, because it's quite a hefty document. I think it's about 50-something pages long.
Let me just hear from everyone that's placing themselves on the record before we get ahead of ourselves here.
Yes, God, please.
Thank you, Worship. May it please the court. Thank you, Worship. Your Worship, I confirm my appearance on behalf of the accused. Your Worship, on this occasion I'm assisted by my colleagues, Mr. Ngaya Toby, who is also senior counsel, and Mr. Vuma is also from the Johannesburg Bar, and we're all instructed, Your Worship, by Ian Levitt, attorneys. We have both Mr. Levitt and Mr. Makonazi from that firm present before Your Worship. Thank you, Worship. Worship, as previously discussed in open court, Your Worship, it is our intention to lead the evidence of a social worker in mitigation of sentence, Your Worship, to place the facts that should assist this honourable court in the passing of sentence in this matter. To this end, we have a witness here, Your Worship, but the witness specifically requests that there be no video footage of her. She has compiled a written report. I confirm that I only handed it to my learned friend this morning, and we have a signed original for Your Worship and a copy for the witness to testify from over and above that. Thank you, Worship. The witness is present in court, Your Worship.
I would have loved to have just a 10-minute just to get my things in order. Things got so.
I know you agreed that you will come in places on the report. I'll just deal with some of the logistics and then I'll hear from you what we will, how we'll follow, what will follow now.
Yes, God, please.
Worship, I endorse my learned friend's comments because we need to make a place for the witness to testify.
Oh, yes.
That's why there are some logistical arrangements that will need to be made.
Alright, let me just do it in this fashion. Firstly, I've received a list of all the media applications about 5 minutes ago. So I do not intend to waste court time by placing each one on record unless you so wish, but then for the record, all media houses present are acknowledged and in court in the proper procedure required. That satisfied, or do you want each media house to be read out with its representative?
Not at all, Your Worship. That's more than satisfactory. Thank you,
Thank you. And the State Advocate Caesar?
No objection to that. Thank you, Worship.
Thank you. Just also to save time, the media, the witness that the defense intends calling, we need to accommodate her or him. I hear her.
To whom?
And therefore we are going to need the witness stand. Okay, so you'll have to rearrange yourselves, please. And also, if it's of any assistance, there will be an order that this witness will not appear visually, only vocal, only oral, no visuals. Or even, please then, if court is not in session, no still photos should the witness enter while court is not in session. Will someone indicate then, once you've done everything, for me to come back in? I'm right here, it's just stepping through the door.
Yes, Your Worship, these are the last orders. Thank you, Your Worship.
Is that it?
That's correct, yes.
You'll send me a message.
That's correct.
Thank you so much, and then for that reason, then we'll adjourn at this point. Thank you.
As the court please, Your Worship. Your Worship, I'm not sure. I did put on record, are we on record? Yes, that the accused has no previous convictions. He is indeed a first offender, according to his SAP 69.
Please proceed.
Do not know what the defense intends leading or asking me to rule on, or so I cannot entertain any complaints if I should adjourn to fetch any document or any anything that I may need, because I am not in my own chambers, and I want to make that very clear. Understood, Advocate Caesar? Okay. There's no other way. I cannot anticipate and bring everything, so I just want to make that clear. Advocate Otis, I'm sorry for that, but it's a distance and it's impossible. I do not know what you may need from me, and if anything, I will maybe then have to collect it in chambers. Thank you so much. Then if you are ready, by all means we may proceed.
We're ready to proceed in litigation of sentence, and the witness that you wish to call to worship is Mrs. Jessie Thompson, who can hold a written report as I said earlier. Thank you. Mrs. Thompson? Thank you. I signed the original for the worship, and I hand it to you, should monitor and has a copy in his possession. And the witnesses will copy it. Mrs. Thompson, can you tell the court briefly what your qualifications are, please?
I do have a BA degree in social work.
You need to speak slowly because at this stage your worship's writing notes of what you say. So you have a BA degree in social work.
A master's degree in social work. And
You have a BA degree in social work, a master's degree in social work, and an LLB.
that is correct.
What is your current occupation?
I am currently a social worker and working part-time at Firearm.
It's hard to hear. I'm close and I'm also back to worship. So you're a social worker and currently in private practice.
That is correct, Your Worship.
You need to raise your voice, please. I know it's difficult, but it's a big room and there's a RC room. Now, in that capacity, you have compiled a report for this accused, is that correct?
That is correct, Your Worship.
Can you please, talking slowly and as loud as you possibly can, take us through your report relating to this accused and the issue of sentence, please?
Please just let me know if I am going too fast. Identifying particulars. Name is Julius Malema. ID number 810303. No, can I start with introduction, Your Worship?
There are, unfortunately, there are aspects that need clarification from the identification. The children, etc., are in that category. So you have to read out the identity numbers and you can just do the language, age, and other details.
No, as long as you're comfortable with that, I just didn't want it to go.
Thank you. I will proceed. Name is Julius Malema. The language.
Numbers
Language is Superior English. Age 44 years. Marital status married. Children 3 children, age 9 and 7 years. And the address is in Sandown, Santon. Introduction. Mr. Julius Malema, hereafter referred to as the accused, faced the following charges.
And I think this is if you read out the charges, the court is fully aware of the charges that the person is convicted of. If you could carry on with the paragraph 2 on page 4, please.
Thank you. The charges against the accused originated from the EFF rally held on 28 July 2018 at the Sisa Dukashe Stadium in Mdantsane, during which the accused discharged the firearm into the air during the EFF's 5th anniversary celebrations. Section 121 and Schedule 4 of the Firearms Control Act 60 of 2000 outlines the statutory penalties for contraventions of the Act. There is no indication that the charges should also be read with Section 51 and Schedule 2 of the Criminal Law Amendment Act 105 of 1997, which prescribes minimum sentences for certain offences, including those related to the possession of an automatic or semi-automatic firearm. The defence requested the undersigned social worker to compile a pre-sentence report. The primary objective of this report is to provide the court with relevant information concerning the accused and his personal circumstances, thereby informing the determination of an appropriate individualized sentence.
Ms. Thompson, sorry to stop you. Can you please attempt to just raise your voice? Even if you have to shout, it's difficult for the people in the back to hear you. Even here in the back. I know it's a big room and I apologize.
Will it help if I just
Those
face...
microphones don't lift to your voice. They don't amplify.
So if I face perhaps differently...
More than comfortable if you want to
As long as you raise your voice, please.
The defence requested the undersigned social worker to compile a pre-sentence report. The primary objective of this report is to provide the court with relevant information concerning the accused and his personal circumstances, thereby informing the determination of an appropriate individualized sentence. The information presented is limited to circumstances pertinent to the matter, in adherence to the principle of confidentiality and the avoidance of unnecessary solicitation of information. The investigation conducted for the purposes of this report includes the following components: 3 personal interviews with the accused, collateral information obtained through interviews with the accused's wife, 2 friends and 2 employees, relevant research including information regarding the specific offences, sentencing options and aspects related to the accused's functioning, supporting documents as referenced in the footnotes and or the resource list, a visit to the Masakaneng Soup Kitchen, Makete Boutique Hotel and Slaying Butchery and Entertainment Hub, conducted during the final interview at the accused's residence in Polokwane. Additionally, an Enneagram personality type assessment was undertaken. This assessment is primarily suited for coaching purposes, providing insight into core motivational drivers rather than observable behaviors. The information regarding the accused's personality is intended to offer context to his conduct and potential behavior expectations and should not be used to draw definitive inferences and or assumptions. Throughout the process, the accused was open and forthcoming, willingly shared information and often incorporating educational elements into discussions, such as the significance of his second name and the rationale behind the focus of his master's studies. The judgment serves as a source for facts relating to this matter. Detailed information pertaining to each of the key elements outlined in the Zinn triad, as well as other relevant considerations, will be presented in the following paragraphs. Recommendations and opinions expressed in this report are based on information available at the time of compilation. The undersigned social worker reserves the right to amend the recommendations and opinions should additional information become available. Personal circumstances, family background. The accused was born on 3 March 1981 to a single mother. His mother had the loss of 2 children, an older sister accused who passed before his birth, and a younger sister who did not survive the age of 2, resulting in him being raised as only child. His sister, who was one of 9 siblings, resided with at least 6 siblings and their respective children in his grandmother's house, located in the main section of Sesheo, a township on the outskirts of Polokwane. At the time of his birth, the extended family, each sibling having at least 3 children, shared a modest 4-room home comprising rooms, a lounge and a kitchen, routinely converted into an additional sleeping area at night to accommodate everyone. The accused environment is very noisy due to the considerable number of occupants in confined space, which led him to value quietness and seek solitude when confronted with excessive noise. Although his grandmother was married at the time of birth, her husband left the family to marry a second wife. The household endured significant financial hardships, subsisting of his grandmother's social grant, his mother's earnings from domestic work, and occasional income from his aunt's temporary jobs. The accused and his cousins were raised together in this environment, learning from an early age to share the limited resources available to them. Despite the challenging socio-economic circumstances of his upbringing, both the accused mother and grandmother consistently modeled a strong commitment to serving others, which profoundly shaped his values and approach to life. His mother, a dedicated Christian, was actively involved in community service through the church, while his grandmother contributed to the well-being of those around her in her role as a traditional healer. These examples established a foundation of communal responsibility that continues to influence his actions and decisions. The accused grew up in the absence of a father figure, as neither his mother nor his grandmother ever disclosed his father's identity to him. To this day, he remains unaware of who his father is. He left his childhood home in 2001 after being elected president of COSAS and returned to Limpopo in 2003. Upon his return, he established his own residence, but maintained those close ties with his family, particularly his mother and grandmother. By that time, his mother's siblings had relocated to RDP houses, while his mother, who suffered from epilepsy, continued to reside with his grandmother. Following the passing of his mother in October 2006, the accused assumed ongoing responsibility for the care of his grandmother. Although he shared strong bonds with both maternal figures, his relationship with his grandmother was especially close. Her death in May 2019 marked a significant loss, yet he continued to honor and maintain a deep ancestral and spiritual connection with her. From an early age, the accused was instilled with the value of family, consistently spending significant occasions such as Christmas and Easter with relatives in Polokwane. Upon earning his own income, he undertook financial responsibility for his extended family by paying his cousins' school and tertiary education fees, and continues to support their entrepreneurial endeavors. The accused considers himself a mentor and elder brother to his cousins and a son to his aunts. According to his wife, the accused's devotion to his mother and firstborn son, together with his strong family orientation, were qualities that attracted her. He provides for his family, approaches his responsibilities diligently, and has maintained commitment to his community even after attaining success. All collateral sources consistently highlighted the accused's deep family bonds and his active community involvement. The accused's eldest son was born in 2006. Although not married to the child's mother, the accused remained involved in his son's life from birth and continued this involvement following their separation. His son would visit during school holidays, and since January 2018 has resided permanently with the accused and his family. He is presently enrolled at the University of the Witwatersrand, pursuing a Bachelor of Arts degree in Philosophy, International Relations and Politics with the intention to further his studies in law. The accused married his wife on 27 December 2014, and together they have two sons aged 9 and 7. Both children attend primary school but are enrolled at different schools. This decision, taken jointly by the accused and his wife, was based on the thoughtful consideration of the children's personalities, needs and best interests, with the aim of allowing each child to develop socially and build independent circles of friends. The accused wife is a dedicated stay-at-home mother, making the accused the financial provider of their household. In recognition of the value of her role, he ensures she receives a monthly allowance, expressing his belief that stay-at-home mothers deserve to be compensated for their contributions. She temporarily paused her career as a qualified financial advisor in the corporate and investment banking sector to focus on raising their children. Nevertheless, she has continued her studies, both to remain intellectually engaged and to prepare for her eventual return to her professional career. Having grown up without a father figure and in a household where parents were not married, the accused is committed to provide his children with a family environment he did not experience himself. He plays an instrumental role in their daily lives as he places significant importance on being actively involved with his family and makes intentional decisions to prioritize quality time together. Significant occasions such as his children's birthdays have never been missed. This illustrates his dedication to his family. Understanding the challenges of public life, the accused is intentional about protecting his children from undue exposure. He strived to be a present and involved father, ensuring that his children enjoy a ground. In his high school years, the accused became involved with the Congress of South African Students, COSAS, an ANC-affiliated organization representing pre-term learners and advocating for improved abolition of corporal punishment, to libraries, and the reduction of high school fees. By the age of 16, he was as the regional chair of COSAS in Limpopo and was provincial chairperson in 1997. Upon being appointed national of COSAS in 2001, the accused relocated to Johannesburg. He recounted the challenges of this period, noting that he was young, without a steady income, and needed to secure both accommodation and the means of survival. Once he began earning, he prioritized sending financial support home to those dependent on him. The accused's first remunerated role was as provincial secretary of the ANC Youth League in Limpopo, an elected position. Notably, prior to this, he served as bronze chairperson of the ANC Youth League in Seshego in 1995, just before his 14th birthday. He was elected president of the ANC Youth League in April 2008 and served until his expulsion in April 2012. Subsequently, on 27 July 2013, he founded the Economic Freedom Fighters, EFF. In December 2014, at the EFF's inaugural elective conference known as the National People's Assembly, the accused was elected as president and commander-in-chief, positions he continues to hold. In addition to his leadership roles within the EFF, the accused has served as Member of Parliament in the National Assembly since 2014. His parliamentary service includes participation in several committees. He is currently a member of the Joint Committee on Ethics and Members' Interests, the Joint Constitutional Review Committee, the Ad hoc Committee to investigate allegations made by Lieutenant General Mdantsane Mkhwanazi, and he acts as a representative of the National Assembly on the Judicial Service Commission. In addition to the noteworthy influence of his mother, and particularly the accused identified the late political leaders Peter Mokaba and Winnie Madikizela Mandela as key mentors and influential figures throughout his life. Based on the published 2024-2025 salary schedule for members of parliament, he receives an annual remuneration of R1,507,841. Physical and psychosocial aspects. Physical, mental and social aspects. The accused reported no physical or mental health issues, and there is no evidence of substance dependency. During his upbringing, he was not exposed to drugs, and aside from a single instance of experimenting with marijuana, he has abstained from drug use. He stopped smoking to avoid drug and alcohol abuse, saying that such substances do not offer solutions to poverty and other challenges. To cope with the demands of his career, the accused relies on the support of his family and friends and finds relaxation in activities such as game drives, listening to music and DJing. He also enjoys playing soccer with his children. As a Pirate supporter, he enjoys attending big matches with friends, colleagues and his children. The accused believes in God, although he does not regularly attend church services except on special occasions. His wife maintains a strong faith. In honor of his mother, who was a long-standing member of his church, he funded the construction of a modern church building, which was officially inaugurated in October 2009. The accused is widely recognized as a revolutionary, someone who gives voice to the voiceless, upholds the responsibility to assist the poor, and is steadfast in advocating for the oppressed. This is consistent with his personality type, which is characterized by a keen sense of justice and a drive to effect positive change. He is willing to be confrontational when necessary and demonstrates an effective attitude towards both his own and the interest of those he protects. In pursuit of improvement, he maintains high standards for himself and those around him, often described as a perfectionist who is focused and committed to ensuring tasks are completed accurately and within set periods. He values order and discipline, expressing a clear aversion to laziness, dishonesty and being caught off guard. He regularly provides positive feedback when warranted, but does not hesitate to address unacceptable behavior. Importantly, once an issue has been resolved, he does not harbor grudges. The accused's personality profile further reflects a preference for maintaining control over situations and a willingness to advocate openly for his convictions. He is motivated by a commitment to do what he believes is right, with a pronounced desire for justice and the protection of others. The profile further highlights his qualities as a natural leader. In situations of conflict, the accused has shown the capability to set aside personal feelings and focus on resolving the issue at hand. He approaches such engagements robustly, ensuring discussion remain issue-focused rather than personal. Nevertheless, he is also capable of strong emotional responses to conflict, typically manifesting as irritation, frustration, resentment, or self-righteousness, particularly confronted with perceived injustice, disrespect, or wrongdoing. He regularly expresses disagreement with instances that he perceives as abuse of authority by persons in high office. Some of these traits were evident during some of his examination and in relation to some of his comments in relation to his guilty verdict. Rather than adhering strictly to established norms, the accused positions himself as a revolutionary intent on changing the political, economic and social systems that are prevalent in the country and internationally. He is comfortable in pursuing alternative approaches, confident in the justification of his actions. Consequently, the accused controversy due to his public statements and the singing of struggle songs. Collateral sources consistently describe the accused as a community-oriented leader who is deeply invested in the well-being of those he represents. While the accused himself shared certain details regarding his community involvement, most of this information was obtained from collateral sources. Where the accused does not personally drive initiatives, projects are generally implemented through the EFF's organizational structure. The accused leverages his influence to mobilize key stakeholders within the community to respond to local needs, often facilitating in-kind contributions to various projects. This approach is intentionally adopted to avoid any perception of financial impropriety. The following was shared with and/or observed by the undersigned social worker. During a visit to the Shushe community, the notable cleanliness and informal settlement, the community benefited from a water supply project funded by local contributions, including the sinking of boreholes to address the inconsistent municipal water provision. The EFF, under the guidance of the accused, supported the community both by supplying water at critical times and by participating in the broader water initiatives, which originated as a grassroots project. Additionally, in May 2024, the Mdantsane Soup Kitchen was established to address food insecurity and alleviate poverty. Operated by volunteers and sustained through community donations, the Soup Kitchen serves daily meals at 1,500 hours, a time specifically chosen at the request of the accused so that school children would have access to a late lunch or early dinner in support of, to support their studies. During an on-site visit, it was reported that approximately 700 meals are served each day. Furthermore, a water tank installed on the premises ensures wider community access to water during periods of municipal supply interruptions. And I just want to take a sip of water. Thank you. Each December, the accused organizes an annual event for matriculants from his former high school, hosting them at a chosen venue such as the Nefeti Boutique Hotel, where they are provided with a motivational speaker, meals, refreshments, and a gift for each attendee. This initiative is designed to remove learners from their usual township surroundings. Although this is a personal initiative, the accused actively seeks sponsorships to ensure its success. He has expressed that his intention is to afford the learners experience similar to those of his children, thereby inspiring ambition through exposure to new environments.
Don't you step on the forward. I think there's a difficulty here to raise your voice.
I'll try to raise it a bit. In reaching out to the elders of the Sisheo community, the accused began by purchasing blankets and slippers for the elderly, later expanding his efforts to delivering food parcels through the EFF. During door-to-door visits in election periods, we observed that many elderly residents lacked proper beds, which led to the launch of an initiative to provide beds, ensuring that no elderly person in these areas sleeps on the floors, a point of personal pride for the accused. Through the EFF-sponsored pilot training program, several community members have qualified as pilots, including the first female pilot from Sisheo, who achieved this milestone in 2023. On his 44th birthday, the accused donated 200,000 to the Tembisa Child Welfare Society. In November 2025, honouring a previous commitment, the accused handed over a disability-friendly house to a wheelchair-bound member of the Sisheo community. Constructed by the EFF, this residence provides dignified and suitable accommodation to an individual who had previously been living in inhumane conditions. Remorse. The accused entered a plea of not guilty to all the charges and, following his conviction, continues to assert his innocence, stating that only a toy firearm was used for discharging the celebratory shots. He has publicly declared his intention to appeal the verdict. Although the accused regards his conviction as wrong, he regrets the incident and the consequent results that people may perceive it as encouragement to handle firearms recklessly. This was not his intent. Criminal behavior and current offense.
We apologize there for that breaking in sound. As you can hear, we are still at the proceedings coming out of the East London Magistrate's Court, and this is in the pre-sentencing hearing of the EFF leader Julius Malema. Let's take you back there.
Arrested on 23 October 2019 and made his initial court appearance on 27 November 2019. The trial commenced on 1 March 2022 and concluded with a conviction on 1 October 2025. The aspects of this case are as follows. Investigations were initiated after a video depicting gunshots fired during the celebration went viral. On 30 July 2018, a spent cartridge was discovered during post-event stadium cleaning. The South African Police Service member responsible for overseeing the EFF celebrations reported receiving no information concerning the discharge or simulation of firearms at the event. The accused was identified as the individual who discharged a .223 Narinka rifle. He possessed the rifle solely for the duration of firing the shots, after which it was handed over to another individual. It appears that the accused received the rifle ready to shoot from someone authorized to possess and handle it, most likely from Tactical Security Services, who provided security services at the celebration event. However, no individual was convicted of supply or transferring the firearm to the accused, and the rifle that was shown in court was returned to Tactical Security Services before judgment was delivered in this trial. Following the event, there were no reported injuries or damages to property. All equipment used at the venue was inspected and no damage was recorded. Seriousness of the offences. In assessing the seriousness of the offences, it is necessary to evaluate both the level of actual and potential harm caused by the acts in question, as well as the degree of culpability attributable to the offender. The Firearms Control Act 60 of 2000 prescribes sentences for such offences, including the option of a fine or imprisonment for maximum periods ranging from 5 years up to 15 years. For a first-time offender convicted of possession of an automatic or semi-automatic firearm, the Criminal Law Amendment Act 105 of 1997 stipulates a minimum sentence of 15 years. As noted by Detroit 2020, page 13, the court in S versus Mulahi observed that the enactment of minimum sentence legislation for the illegal possession of automatic or semi-automatic firearms was a response to the frequent use of such weapons in the commission of violent crimes. A central objective of the Firearms Control Act 60 of 2000 is to curb the proliferation of illegally possessed firearms and to prevent crimes involving firearms by removing such weapons from circulation. This purpose significantly heightens the seriousness of firearm-related offences. However, in the present matter, the considerations mentioned above do not apply and certain mitigating circumstances are evident. The accused obtained the firearm from an individual, most likely affiliated with Tactical Security Services, who was authorized to possess and managed a licensed firearm. He did so solely for the purpose of discharging celebratory shots at the event. There is no indication that the firearm was acquired illegally for a prolonged period or with any intent to facilitate further criminal activity. It appears that the firearm was returned to its lawful custodian promptly thereafter. The accused's possession of the firearm and a single round of ammunition was limited exclusively to the period during which the celebratory shots were fired, which, while not precisely timed, is estimated to have lasted less than 1 minute. Additionally, the Firearms Control Act seeks to uphold the constitutional rights to life, and bodily integrity, and to penalize the negligent or unlawful use of firearms. In this context, the following considerations are relevant. There is no evidence that the accused intended to cause harm. Nonetheless, the court found that he discharged the firearm in a public space without implementing the necessary precautions to ensure the safety of people and property. By neglecting to take such precautions, it has been said that the accused acted recklessly, thereby endangering the lives of celebrating members, bystanders, and residents of neighboring areas, and risking property damage. Such conduct could have resulted in loss of life. It has also been said that the careless and reckless discharge of firearms in a public setting conveys an inappropriate message about gun safety and responsible firearm use, particularly when a prominent leader exhibits such conduct. The actions of individuals in positions of influence are likely to be emulated by their supporters, thereby warranting a more severe assessment of their behavior. It has already been noted that the accused regrets the incident and the consequent perceptions it might have created. However, there was no evidence indicating any harm to a person or damage to any property. Planning. The firing of celebratory gunshots was deliberately planned as a distinctive element of the event, reflecting the established tradition of incorporating unique features into each celebration. For instance, during the 10th anniversary, the accused approached a section of the stage that elevated into the air while red and gold confetti was released from cannons. Available information does not suggest that the planning of this activity was undertaken with the intention to commit an offence, endanger life, or cause damage to property. Interest of society. The interest of society is upheld by imposing a sentence that delivers the greatest benefit or minimises potential harm. In considering an appropriate sentence, it is important to consider society's economic stake in the cost of the criminal justice system, ensuring that any punitive measure is justified by the tangible advantages it provides. The objectives of punishment are rooted in the protection and advancement of societal interests, encompassing prevention, deterrence, rehabilitation, and retribution. Prevention. As noted by Blanche, the incapacitation of an offender becomes especially significant when the individual poses a danger to society and when imprisonment is the only means by which the public can be safeguarded. In this instance, prevention is not regarded as a primary objective. The accused is a first-time offender, did not act with the intent to cause harm, and no person was injured nor property damaged because of the offence. Furthermore, despite the lapse of many years, no subsequent offences have been committed. Deterrence. There are two recognised forms of deterrence. General deterrence, which aims to dissuade members of the public from engaging in criminal conduct, and individual deterrence, which seeks to prevent the accused from reoffending. The accused's personality profile suggests that his actions are driven by a desire to behave correctly and ethically. He has emphasized his position as the leader of the fourth largest political party, highlighting the considerable influence he holds over young people. He recognizes that he cannot credibly encourage others to respect the law if he himself is found guilty of a criminal offense. This awareness is expected to exert a strong individual deterrent effect. Furthermore, having been tried and convicted is also humiliating to the accused, serving further as an individual deterrent. Justice Edwin Cameron, a retired judge and current inspecting judge of Correctional Services, wrote in an article dated 9 August 2021 that the most effective deterrent to crime is the certainty of consequences. Certainty of investigation, detection, arrest, arraignment, prosecution, and ultimately punishment. This principle was also affirmed by the highest courts, as reflected in the case of S versus Mokonyane, which stated that the greatest deterrent to crime is the likelihood that offenders will be apprehended, convicted, and punished. It is the certainty of punishment rather than the severity of the sentence that is likely to have the greatest deterrent impact. Rehabilitation. Rehabilitation seeks to assist the offender in becoming a law-abiding member of society. While the accused maintains his innocence, he acknowledges the inherent risks of discharging a firearm in a public setting, and regrets that the perception could be created that it is acceptable to recklessly discharge a firearm. He is a first-time offender and has not committed any further offences over the past 7 years. These factors, together with the individual deterrence previously discussed, suggest that rehabilitation is not a primary consideration in this case. Retribution. De Blanche asserts that retribution serves as the underlying principle of all sentencing, forming an integral part of the concept that every sentence must be proportionate and appropriate. This determination should be made objectively, considering the Zen trial and the degree of culpability attributable to the offender. Cameron, Gore and Suraj Paul indicate that justice for victims requires accountability for blameworthy conduct, but not necessarily through the prison system. The question is asked whether we would not be better served by expanding our idea of what constitutes justice to include ideas of restitution and reparation. The above-mentioned authors further indicate that even if embracing retributive and vengeful instincts is warranted, there is a danger of disproportionate and excessive forms of punishment. In line with these sentiments, qualitative research conducted among legal practitioners has revealed that the justice system currently places excessive emphasis on retribution and relies heavily on imprisonment, often to the detriment of restorative justice alternatives. Sentence options. The determination of potential sentencing options is shaped by statutory requirements governing sentence severity, as previously discussed in relation to the seriousness of the offence, and which indicates the option of a fine and imprisonment. In this context, sentencing objectives remain the primary consideration alongside the accused's personal circumstances, especially when evaluating the appropriateness of a custodial sentence. While recognizing that each offender and offence represent unique factors, reference to certain sentences commonly imposed in comparable cases offers valuable guidance in identifying suitable sentencing options. Sentencing trends. In his analysis of sentencing practices pertaining to the unlawful possession of semi-automatic firearms, the Tour examined sentencing trends in the context of the Criminal Law Amendment Act 1997 and the Firearms Control Act 60 of 2000. The findings highlighted several key aspects. The implementation of minimum sentencing legislation for the illegal possession of automatic or semi-automatic firearms is linked to the prevalence of such firearms being used in the commission of violent crimes. In considering the application of minimum sentences, the specific circumstances under which the possession occurred, as well as the intended purposes of possession of the firearm, are critical in determining whether substantial and compelling circumstances exist to justify a deviation from the minimum sentence. Courts are more inclined to impose the prescribed minimum sentence in instances where the accused is also found guilty of other serious offences such as murder and robbery. Considering the facts of this matter, it falls outside the above-mentioned considerations regarding a decision to impose a minimum sentence. Furthermore, in line with the Machongo matter, bearing in mind that no evidence was obtained which suggests that the accused was forewarned about the likelihood of the application of a minimum sentence, it is respectfully submitted that a minimum sentence is not applicable. Despite warnings in the press with regards to dangers of celebratory gunfire, no case law on conviction or sentencing for discharging a firearm for celebratory purposes could be found, indicating that charges are not generally instituted in this regard. The accused may be the first person charged for discharging a firearm for celebratory purposes. Annexure 2 of this report referenced judicial decisions concerning the discharge of a firearm in public or incidents of reckless endangerment to persons or property. Consistent with the sentencing provisions outlined in the Firearms Control Act 60 of 2000, prevailing judicial trends indicate that sanctions consist of a fine and/or a wholly suspended term of imprisonment. However, where the discharge of a firearm resulted in injury to another individual, courts have deemed direct imprisonment to be an appropriate sentence. In the matter referred to in South African Human Rights Commission and another versus Malema and another, the court deemed the fine to be an appropriate sanction, notwithstanding the fact that the firearm was discharged in a conflict situation. Conversely, in the Oscar Pistorius case, where the firearm was discharged not only in a public setting but also within a confined space, thereby heightening the risk of harm to individuals and property, the court found that a wholly suspended term of imprisonment was justified. Imprisonment, whilst the state's view on an appropriate sentence is uncertain, it is necessary to address relevant information relating to imprisonment. Imprisonment is widely recognized as the harshest form of punishment, generally justified by the objectives of retribution and deterrence. According to Cameron et al., except for in the most extreme cases, imprisonment remains a terrible thing. It has profound and far-reaching consequences for families, which extend across personal, social, financial, emotional, psychological, and physical domains. Since the family is often considered the foundation of society, any harm inflicted on it may worsen societal problems and contribute to elevated crime rates. In this light, Cameron et al. Advocate for comprehensive reforms within the criminal justice system, particularly the prison system, to enhance public safety and foster a healthier society for all. With regard to the accused's personal circumstances, several key factors warrant consideration. The accused is the main financial provider for his family. Therefore, a custodial sentence would directly threaten the family's financial security. He is the father of 3 children aged 9, 9, and 7, and husband to his wife. As an actively involved parent with a strong family orientation, his absence would disrupt his children's and wife's emotional, social, and psychological well-being. It is important to highlight that accused receive a custodial sentence in 12 months without the option of a fine. He will be rendered ineligible to serve as a member of the National Assembly. This disqualification will persist for 5 years following the completion of the sentence, thereby restricting his ability to represent his constituency during this period. The accused enjoys notable support within the South African society, with many subscribing to his philosophy and expressing confidence in his leadership within key institutions such as the National Assembly. His removal from office would inevitably create a void for the communities he represents, potentially diminishing their voices and the hopes he has consistently championed on their behalf. Finally, the accused's active involvement in community initiatives would be interrupted, placing the continuity and sustainability of ongoing projects at risk to the detriment of the community. Considering the facts of this case and the personal circumstances of the accused, it is necessary to carefully assess whether any form of imprisonment would constitute the most appropriate or just outcome. Evaluation. The purpose of the evaluation is to assess the risk of recidivism and to identify key factors that may inform and guide sentencing decisions. The following are considered protective factors which substantially reduce the risk of reoffending. Strong social support. The accused learned the importance of family from a young age, continued to maintain close family relations, and relies on the support of his family when necessary. Resilience, coping abilities, and thinking skills evidenced through a progressive career trajectory despite challenging childhood circumstances. Low risk in terms of criminal history. The accused, the 44-year-old first-time offender, committed the offence at the age of 37 and fully cooperated with court for 5 years. He has not reoffended since. Pro-social behaviour, as indicated by his active community involvement. Although not part of the sentence, any form of pain or discomfort an offender suffers as a result of committing a crime can be seen as punishment and moral retribution. The following is noted in this regard. The lapse of more than 7 years between the commission of the offence and and conviction is regarded as a mitigating factor. Beyond the financial burden, the court in S versus Michelle acknowledged the considerable mental anguish experienced by appellants who endured prolonged uncertainty regarding their future, recognizing this as a relevant consideration, and humiliation and public shame, having been morally declared of having done something wrong. Although the accused maintains his innocence, which is often viewed as a risk factor, his recognition that a criminal conviction would undermine his ability to credibly promote respect for the law notably diminishes the likelihood of reoffending. As a revolutionary, the accused frequently challenges established conventions, while his readiness to address perceived injustice may continue to invite controversy and potential legal scrutiny. These actions alone do not necessarily heighten the risk of him reoffending unless future criminalizes specific behaviors such as hate speech. Conclusion: given that all 5 charges stem from a single incident and video footage shows that the accused did not load the firearm, it is recommended that the charges be considered collectively for sentencing purposes. After a thorough assessment of the accused's personal circumstances, the seriousness of the offences, societal interests, and relevant legislation and case law, the following sentencing proposal is made. Impose a fine that reflects the gravity of the offences, with the fine suspended to encourage continued lawful behaviour. Restrict the accused from obtaining a firearm licence for a specific period as an ongoing deterrent. Require the accused to make a monetary donation as restitution to Gun Free South Africa, an NGO focused on reducing gun violence in South Africa. It is acknowledged and accepted that the duty to impose an appropriate sentence rests with the Honourable Court.
That is your report. Next to your report, you've also detailed your resources that you utilize in the compilation of the report and who you actually consulted. That's at page 36, is that correct?
That is correct, Your Worship.
And then further, the cases that you cited in the report, the legislation and documents that you have regard to.
That is correct.
You also, as I understand, you report have regard to the Worship's judgment in the matter.
That is correct.
And you've also done, as an annexure 1, a background of your background as an investigating social worker.
That is correct, Your Worship.
On pages 39. Can you take us through those qualifications, please? And only touch this, it is only to repeat them. Just in regard to your experience and professional leadership status. It's on page 39. We've heard about your first 3 qualifications being a BA in social work,
Correct.
which you obtained in 1986, an MA in social work in 1999, and an LLB in 2005. You then have a postgraduate certificate econometric assessments in 1999, Perspective Training College, and you're a certified Enneagram practitioner from 2023, a procedure that you referred to in this report.
That is correct.
Then could you take us through 2.2, please, your professional membership and status?
So I am registered as a social worker with the South African Council for Social Service Professions, with my registration number noted. Also a member and a member of the National Executive Board for the South African Associations for Social Worker in Private Practice. I was admitted to practice as an advocate on 21 August 2006, however never practiced, and is a non-practicing member of the National Bar Council of South Africa, and also registered as non-practicing with the Legal Practice Council. I've been appointed as a member of the 5th Professional Board for Social Work in 2022.
Those are your memberships. Can you take us through your experience, please?
So I've been practicing as a social worker since 1997. Started my career at the Kroonstad Correctional Services Facility. It was interrupted thereafter doing work at a church and family organisation, I have thereafter worked another 6 years for the Department of Correctional Services. During my department with Correctional Services, I worked with sentence offenders and both in prison and serving community-based sentences. And with the introduction of correctional supervision as a sentencing option, I established the function rendering these reports to the court for the Wynberg and Rounded Magistrate courts at the time. I have, since my resignation from the Department of Correctional Services in 1999, continued to do pre-sentence report on a part-time capacity in my private capacity.
Then you have further additional fields of expertise, which include children's court investigations, family mediation, student supervision, and supervision of student supervisors.
That is correct, Your Worship. And then alongside the part-time private practice, I've also worked in the corporate environment where I have been trained and had extensive experience in risk management, which I found to be contributing and beneficial to my work as a social worker.
And you were employed previously by the Department of Correctional Services for 9 years.
That is correct.
And the Christian Social Council for 3 years.
That is correct, Your Worship.
And it says here you have 26 years of private practice experience, mostly in the part-time capacity.
Correct.
You've then given a list of matters in which you provide a pre-sentence report. On page 40, is that correct? There's no need to look through.
That is correct, Your Worship.
And then at page 41, it's an annexure to the 13-year report, and you refer to sentencing trends, where you've had regard to particular reported and unreported cases, and the convictions, circumstances, and sentences that were imposed in those various cases.
That is correct.
And that can take us through to even page 42. Is there anything else that you'd like to add in relation to the sentencing of this accused before this honourable court?
Nothing to add to my report, perhaps just the observation, and I think during my experience and working with the accused, his respect and the importance of respect to him was always notable. And when I look at the seating of the people, it seems like the elders...
I'm going to correct it, Bishop. I'm sorry, you're speaking to her worship, but now there's a problem because you're talking in that direction. It's impossible to hear.
Sorry, Your Worship.
Can you just repeat? I beg your pardon if you can go back,
in the context of my experience of the importance of respect to the accused, when I just noticed the seating in the court, it seems also that the elders, which is a very important community to him, and seating was preferenced. It's just an observation, but nothing else to be added to my report.
In other words, respect for elders.
Respect in general for people, but specifically for the elders.
Finally, what would your view in relation to incarceration in these circumstances that prevail in this matter be?
I think if I can summarize the views from my report, is that when it comes to incarceration, and I haven't done the detail or add any detail about it, but the reference to the book by Cameron and et al. Deals with the circumstances in imprisonment, with the overcrowding of imprisonment, the need for can I continue? The need for reform to look at how we sentence differently, recognizing the place for imprisonment, but that there are certain matters where a custodial sentence would not necessarily be the only appropriate option, specifically where it wouldn't serve all the purposes of punishment, I think a preference would always be that imprisonment would be where prevention would be a key deterrent, a key purpose of punishment. But other than that, I think the circumstances of the case would dictate it. So when I look at this as compared to the other cases of a more serious nature, I couldn't find any intent that the weapon was used or obtained with the aim of committing any other offences. It was specifically for the purpose of the celebratory shots. It was in his possession for a very, very short period of time, making it very distinguishable from all the other cases where a period of imprisonment would be imposed.
Aligned to that answer, there are two aspects that come to mind. Firstly, the issue of recidivism. You've highlighted in your report the fact that since the date of the commission of this offence, there have been no other charges of any nature levelled against the accused. Are you aware of any other incidents in which he's been cited or referred to as having been in possession of a firearm illegally or firing shots in public in an illegal manner?
For celebratory purposes?
For any purpose. Are you aware of him ever being involved subsequent to this event in the firing of any firearms thereafter?
I'm not aware of any other cases being brought against the accused.
And then, finally, you've said it in your report, but I think it's something that requires highlighting. Were you, in your research, able to find any cases that dealt with the discharge of firearms in public areas in celebratory events, be it one of a funeral and or an engagement or anniversary of some sort or birthday? Were there any cases dealing with sentencing in those circumstances?
I couldn't find any cases dealing with a person being accused or sentenced or any challenges of sentences or convictions in this regard. I have, however, seen warnings in the press where people are often warned about the risks and the seriousness about it, asking people not at New Year's, at celebrations, to do that. I also picked up an article indicating that at the funeral of the late Winnie Madikizela Mandela, afterwards there were shots fired from her home in a celebratory context. I'm not sure if anyone was arrested in that regard. I haven't found any information to that extent.
Oh, thank you, Madam. I have no further questions. Thank you.
Your Worship, I'm very tempted to start with my cross-examination, but I've lost a few pages where the witness has testified, just for the sake of thoroughness and completeness, because I did get the report only this morning, to go through it again to ensure that I haven't missed anything regarding this particular report, because the witness did testify quite fast. Thank you. I need an adjournment. If I can, I don't want to say 15 minutes for the pages. It is a huge document. We also didn't have tea break. If you can make it a little bit longer, maybe by 20 minutes, Your Worship.
After we return, so that we can, you can't say no and stay.
No, I'm just looking at them here, Bishop. I'm trying to show them. Yes, I'm just trying to show.
Okay, just keep that in mind. Will you just then please, since I'm not close, I don't know what you're doing, that a message be sent to me.
Yes, Your Worship. I might be ready even quicker than that. I just need to be certain.
So then I'll end the court at 12:15. If you are not ready or you want to claim the
Yeah, by 12:15, Your Worship. If I'm ready before that, I will have Your Worship call.
said there were no two adjournment and court staff did not have. Let me enter at 12:20. If it's sooner, just send me a message.
Thank you, Worship.
If you're not ready at 12:20, I'll enter and we will complete the meeting. In order to
Yes, Your Worship. Thank you, Worship.
Thank you.
There you have it, an adjournment until 12:15 in the pre-sentencing hearing of the EFF leader, Julius Malema, there, just to allow the prosecution to get acquainted with the pre-sentencing report that was just read into the record by the social worker, Jessie Thompson, there. As you were following those proceedings,
start from the last portion to the front, because it's the part I remember most, the last evidence that you gave. I want you to go to page 41 and 42, that's the last 2 pages of your report, where you basically state that the cases that you were involved in and the sentences that you were imposed and so on. Firstly, I'm going to speak about the 1, 2, 3, 4, 5. The first case is on page 41. Do you still have reports of those cases with you? It will be interesting to see how this report has been passed before the need to compare it with your current report, because in most of these reports, in my experience, they are copy and paste jobs. Can you go to page 40? You're referring to Quirk case. Can you still remember the facts of that particular Quirk case that you dealt with? You're referring to Quirk case. Can you still remember the facts of that particular Quirk case that you dealt with?
Who has been used to the terrorizing giving it this children's law and had connections in the sense that the person was not helpless and that there would be no help to reach out to the police because of the deceased person's connections. And then there was some a number of mitigating factors that played a role and contributed to the incident.
What was your recommendations in that matter?
The recommendation in that matter was to have a reduced sentence, either to 76 or to 76 the circumstances of the and contributed and considering some of the detail
What was your recommendations in that matter?
The recommendation in that matter was to have a reduced sentence, either to 76 or to 76 the circumstances of the individual.
So in other words, you recommended one of the sentences in a murder case. Basically, you recommended that a non-custodial sentence be imposed, one of the sentence options in such a serious offense, such as murder.
Considering the specific circumstances of that particular case, there were a number of other murder cases that are also done where...
So in other words, you recommended one of the sentences in a murder case, basically you recommended that a non-custodial sentence be imposed. Do you know if this Quirk matter was ever taken on appeal and what was the outcome thereof? I would have loved to know. Yes, because the sentence, I find it from my experience, that is not usually the kind of sentences that are or imposed in murder cases. This Quirk matter was ever taken on appeal and what was the outcome thereof? So in Lawton, in Ranger. I see the accused was charged there with attempted kidnapping, attempted murder, culpable homicide. I think you are referring here, you said he was found guilty, accused 2 and 3, yeah, was found guilty, I think, of kidnapping, culpable homicide. Can you just give us a description as to what transpired there, if you still remember the facts of that particular case?
Well, it is, there were a lot of detail about the case. It was probably considered to be something because it was a cold case, another case, and the charges were as it is. The person disappeared and her body was later found, the remains of a letter was found in the house that's been renovated for the murder and the investigation started after that. So obviously considering this and the circumstances again, to case the detail of the matter and the circumstances of the accused, the main accused, my conviction at the time was that imprisonment would be only option to consider long-term imprisonment.
Listening to the facts, as you explained it, that's not the Rasuki matter where the lady was found after. Is that not the case you're referring to? Yes. Can you recall what was your recommendations? You said.
So I had first she wasn't found, the man she found out that I had received the letter confessing to the murder.
So you did recommend that the lesser term of which one was your client?
I had a conclusion to say that imprisonment was the only long-term option.
And you say you don't know what was the term of imprisonment that was imposed.
For the two characters, not for the
Less than 5 years, and they were charged, you said, with culpable homicide. Why would that be culpable homicide when this is actually a murder case that we're dealing with?
I think the term of imprisonment for the first case was 3 years. I can't recall.
There's a request that you speak louder.
I'm sorry. Apologies.
Then I want to deal with the third case in you're referring to a coup where the person was charged with negligent use of a firearm, causing injury to somebody, discharge of a firearm in a built-up area or any public place, assault with the intent to do grievous bodily harm, pointing of a firearm. I see there's a written conflict situation. It was probably your brief description of the situation or the facts of the case. Can you still recall that? Description of the situation, the text of the case. Can you still recall that?
High level, that's why.
And I note, what was your recommendations in that matter?
Rival with families in conflict situation over a period of time, and it arose the conflict spread over to a public place, considering which where the incident occurred. Part of that,
what was your recommendations in that matter?
a lot of harassment from the other communities.
I know it was one non-custodial, whether it was specifically a foreign, I can't remember,
that then considering afterwards, not only the facts of the case, but also the personal circumstances and the mitigating circumstances of the accused. And after part of that...
Would you agree with me? You have already now mentioned in 2 instances where serious charges have been faced by the accused, where your recommendations was basically either non-custodian, and in the murder one, you recommended 276 H or I. H meaning at home, he must serve it at home. H meaning he must serve it in custody in a murder matter, which means the maximum sentence when you do impose I is 5 years imprisonment. In this case, it's such a serious case, I see you note that the fine was 50,000 rand that the person had to pay. You're also referring to the Bezos matter. It says it's a private prosecution, assault with intent to do grievous bodily harm. You said it was a not guilty plea from the little note. I don't want to go through your report. Do you know the facts of that particular case? And what was your recommendations relating to that case? You're also referring to the Bezos matter. It says it's a private prosecution, assault with intent to do grievous bodily harm. You said it was a not guilty plea from the little note. I don't want to go through your report. Do you know the facts of that particular case? And what was your recommendations relating to that case?
Shortly, facts were that it was domestic relationship related domestic fight, and the wife was injured. The person was prosecuted, approached Forum, and a private prosecution followed. And you considering again, apart from the cases. So these cases, we have a number of others that I've done, but I will select specifically because of that. Although it's serious, the different circumstances to this case.
Sorry.
Personal circumstances and mitigating circumstances, because at the end, from cases in general that you have, all the cases in general, I have dealt with numerous murder cases where it is really the purpose of deciding what are the mitigating circumstances have indicated to the and these were when you look at the circumstances of the person and because at the end, when you look at it within the context
Ms. Thompson, we're going to get you, we're jumping the gun. We're going to get to why you were asked to attend to these cases. I first need you to answer this question where I specifically asked, what was the facts of this case? What was your recommendations? That was the question.
It would have been non-custodial, but I can't recall the recommendations.
The facts?
Facts was a domestic incident of violence where the person was injured. No prosecution followed. There was a long process prior to that. It would have been non-custodial, but I can't recall the exact recommendations. The person was convicted, and the facts was a domestic incident of violence.
Also non-custodial. You said it's a female that was injured, who's the complainant in this matter, yet still you recommended a non-custodial sentence. It basically in a gender-based violence issue. The fine that was imposed was 100,000 rand or 12 months imprisonment. And then you also note that 6 months correctional supervision, performed 20 hours community service at a shelter for abused woman. What was the reason for you to make such a recommendation in instances where there was some domestic violence and domestic issues, that this was the proper? 12 months imprisonment. And then you also note that what was your recommendation? Perform 20 hours community service at the shelter for an abused woman.
Correct.
It's also unfortunate. I also would love to have a look at those reports. Then we go into Sekwati. You refer there as an arson, malicious injury to property. I also want the same question as before. Your facts, your recommendations.
Unfortunately, I didn't bring the cases with me.
Reports. Then we go into Sekwati. We refer there as an arson, malicious injury to property. I also want the same question as before. Your facts, your recommendations. Yes.
Facts of the case where it was an incident of a domestic fight. So it really spread from the relationship and a very difficult relationship that were done. And the recommendation again was non-custodial, specifically considering that she is also a primary caregiver of 2 children. At the time, she also, the one child was her biological child, the other one was a foster child. So getting further comfort that if she's been considered appropriate to have a foster child, there were not any other red flags making her a danger to any other person.
The sentence you said you recommended non-custodial because you've explained that she was a caregiver, and so regardless of the seriousness of the offense being arson and so on.
So I can't, if I recall correctly, the recommendation was a period of imprisonment suspended with a condition of correctional supervision. The court opted to still go non-custodial, but a different sentence.
Yes, almost to the letter adhering to your recommendations. Isn't that so?
That one was not really to the letter, but yes, it was close.
Do you know, I still remember a case, I don't know whether you know, during the feast must fall, one of the gentlemen took a petrol bomb and he threw it into one of the police vehicles, and he got 8 years direct imprisonment, if my memory serves me correctly, for almost the exact same offense that he committed.
Circumstances sound very different. A fire was lit in the house. It was nothing throw at something. If we talk about the arson, there were no injuries and there were no one in the house.
My idea is that if you were the one assessing him, you would have had a much better outcome than the one that he had, where to serve actually direct imprisonment.
I wouldn't be able to say whether it's so because I do not have the details of the matter and his personal circumstances.
It's going to take me a while to go through this, but I want to do just the second page and then I want to stop there because it's quite a number of cases, but you already see where I'm getting at.
Yes.
Is that correct? Referring to Nene versus the state, where the accused was sentenced or charged with murder and reckless dangers to a person and property. A security guard, can you just go again? The facts of the case, your recommendation.
What page are you in?
I'm now on the page 41.
Okay, so on page 41, just for context, Your Worship, I looked at trying to find, I've previously already mentioned, I couldn't find any cases of similar to this one where shots were fired in a celebratory extent. So I was looking for cases where firearms were discharged and similar type of charges, although the context is different, to get an idea of what the sentences are. And this is just really to say these are the things that I looked at. It's not cases that I've dealt with.
Okay. But on the 5 that you've already, that I showed you, you already picked up the pattern that I'm trying to point out to you, that you made certain recommendations and most of them were almost followed. Is that correct? in very serious cases?
Based on the cases that are selected to show there are exceptional circumstances, yes, that would be the pattern. If I had expanded the list and selected cases where the circumstances were not so exceptional, you might have come to a different conclusion. But I have not done that.
So it's only the cases with exceptional circumstances that are referred to you.
Some of them. There may be others. I had to have a look as to which were these type of cases where the circumstances were exceptional despite the seriousness of the crimes.
Do you regard the issue of the gentleman I just referred you to, about the one who was protesting for free fees for students, in the heat of the moment throwing a petrol bomb as he's running around, being a young gentleman, still a student, throwing a petrol bomb in the police van? You don't regard that as like those exceptional circumstances?
I wouldn't know because I do not have the full picture in terms of what happened, what contributed to it, what is his personal circumstances, which is a big part of what you look at. And I cannot comment with it without the full picture.
I'll try to get a full picture from counsel. I think he was appearing in that matter for the leave to appeal application, Mr. Dukashe. But in those, the facts that I've just given you would not regard this as exceptional.
There are certain things that had to be explored. Because it's a young person, it was in terms of specific cause that was followed. But other than that, as I say, it's not only about the facts of the case, it is really connecting the person with the facts of the case and looking at all together, which would make the exception, not necessarily the facts of the case only. Because if you look at some of the facts of the cases that are given, it's not that exceptional. The exception comes in when you add the component of the person to the case.
Do you agree that only the people with means would be able to approach you for you to actually compile a report because you need to be paid for work done, services rendered?
That is correct, that people need to be paid for my services rendered. But I also do in exceptional cases again, I may do a report for a reduced rate to make it more accessible. And in general, my approach is to make sure that my costs are capped at a specific amount and that it doesn't exceed that amount to make it more affordable for a wider audience, irrespective of who the person is.
If it wasn't in court, I would have been so tempted to ask you what that rate is. You don't have to answer. But the point that I'm trying to make is only people with means are the ones that are able to approach you. Those who can't afford it will end up in prison because they don't have the benefit of your comprehensive report with your LLB and all your qualifications.
People with limited means would also be, I have been approached previously for cases where I have accommodated that on request of the legal representative to do a report at a reduced price for people with limited means. And yes, even though you do not want me to state the specific amount that I generally ask, I can confirm that it is, for my appearance, the court, the investigation, everything, it is below 20,000 rand, way below.
I want to go to your conclusions in this particular matter. We are going to page 30. Let's start at page 34. My eyes are page 34.
Okay.
I want you to go to the conclusion where you said they basically given that all 5 charges stem from a single incident and video footage. The accused did not know the firearm. It's recommended that the charges be considered collectively for sentence. after a thorough assessment of the accused's personal circumstances, the seriousness of the offence, societal interest, the relevant legislation and case law, the following sentence proposal is made. Impose a fine that reflects the gravity of the offence, with the fine suspended to encourage continued lawful behavior. 91.2, you said restrict the accused from obtaining a firearm license for a specific period as an ongoing deterrent. And 91.3, you said require the accused to make a monetary donation as restoration to Gun-Free South Africa, an NGO focused on reducing gun violence in South Africa. You are recommending that the accused pay his way out of jail in this conclusion. Is that not correct?
What I am concluding is that jail may not be the necessary approach to go. There is a reason that there are fines. The Act prescribes the fines, and one can then argue that every person who can afford it can pay their way out. Where it is one of the allowed options within the Violence Control Act for these contraventions.
So the more affluent ones must remain outside jail, the poor ones must go straight to jail because they can't afford to.
You're free to leave, but no one will disrupt the court proceedings in any manner. The ones who sit down and you are quiet, you remain. The rest, I will order to leave, without exception. Understood? It's your choice. I won't ask again.
Your Worship, the fact that a person can afford a fine, if it's a severe fine, that will make it less of a punishment. And the converse of that is then where a fine would have been appropriate if you are an affluent person and can afford it.
Yeah, I'm voting Yaguzo.
Be afforded because of the perception that may be created and therefore go to jail. If there are other circumstances that would say maybe that is not necessarily the only option.
Kunemidlalo emhlanje yeBetway Premiership kulempela sonto kanti Orlando Pirates.
So where the legislation provides for it as the simplest option, and if a person is affluent and the case is serious, a heftier fine can be imposed. The fact that a person is more affluent.
Lezi indaba zehora lokuqala sekwethulela zona bukhoma ekomkhulu le-SABC e-Auckland Park eGoli. Mbukele nazi ezinohlonze emini nje. Ziqalile namhlanje izethulo ezandulela ukwethulwa kwesigwebo ecaleni elibhekene nomholi we-EFF uJulius Malema lokuqhumisa isibhamu ezilangalaleni emcimbini waleli qembu ngo-2018. uMalema walahlwa yicala ngomfumfu wanyaka.
In certain circumstances where the facts are exactly almost very close to the accused case, where people have to go to jail and the periods that they have to go to jail.
Namhlanje kubanjwa inkonzo yesikhumbuzo yabafundi abayi-14 abashone ngesihluku engozini yetekisi eVanderbilt Park ngomsombuluko. Umshayeli obosolwa ke ngokubabulala u-Ayanda Dludla ubevele okokuqala enkantolo izolo.
Njoba ingane ezingayanga esikolweni kungesizathu sokuthi uhulumeni wethu esimthandayo usihlasele izolo.
eGoli ngenxa-ke yesiteleka sabashayeli abathutha abafundi abakhala-ke ngokushaqwa kwey'moto zabo okuthiwa-ke azikulungele ukuba-ke semgwaqeni.
Oh, what a ball from Rele Mufokeng! Oh, special!
Kanti uma sibheka kwezemidlalo kunemidlalo emihlanu ye-Betway Premiership kule mpelasonto kanti i-Orlando Pirates izobe ibheke ukuphindela-ke esicongweni selokho njengoba-ke izobe idlala okokuqala ngemva kwekhefu le-AFCON noma-ke ivakashela-ke iseKhukhune United kusasa. Ukuthola kube kwembukeli ngiyakwamukela ezindabeni zehora lokuqala ezingunqa phambili kanti futhi-ke ezihamba phambili la ku-SABC 1 Mzansi for sure kanjalo-ke naku-SABC Lehayi. Igama lami nginguDawud Phungula, mbukela-ke singene kuzo ezivutha amalanga bimini nje. Sidima. Shosho Sidima, how's it?
Hi,
Kaphileka mfowethu?
I'm good. How's it? I can't hear you properly. Can you make your sound louder a bit for me?
Ngicela nikhuphule nganiza kulithu ngalapho. Angazi-ke manje ukuthi usongizwa kanjani.
You are very...
Half past 1, Your Worship?
Everyone in agreement say yes, everyone not in agreement be quiet.
We're in agreement.
Oh, what's that?
1:30, we're in agreement. Take a break now till 1:30.
Suitable for everyone? Don't worry.
Network ya geza yo. No, senje kwa pako na.
Don't want to put one here in one too. Everyone ready for us to proceed? No, but I'll have to. Thank you. Sorry, I don't know if I'm too soft to you. Is everyone ready for us to proceed?
I'm ready, Your Worship.
Thank you. Advocate Alice, thank you. The witness, on resumption then, you are reminded you are still under oath in this matter? Yes. And that the state will then continue now with cross-examination? Yes. Thank you. I think we are clear on where you stopped during your cross-examination, Advocate Sisa?
Yes, Your Worship, thank you.
Thank you.
Mr. Thompson, you made part of your recommendation is because the accused didn't load the firearm himself. It was handed to him. He had it for a relatively short period of time, etc. Is that correct?
That would be part of the consideration. That's correct, Your Worship.
I'm going to refer to you on page 11 of my notes, the notes that I have with me in respect of a particular case, State versus Asma. It's the second paragraph on page 11. It's referred to as State versus Asma. Your Worship, the references are the footnotes in case Your Worship wants the citations of the particular case.
Are you saying page 11?
Page 11 of the document I handed up. Your Worship, page 11 is on top. The 11 is
You've
right.
not yet handed up the document, Advocate Sisa.
I did ask the court orderly to hand Your Worship a copy. I was going to use this during arguments. Say, page 11, the second. Yeah. Magistrate.
Thank you. Thank you, Sir.
Citation is at the footnote, Your Worship. The State versus Asmal. I'm going to tell you, the Supreme Court of Appeal referred with the approval to Marikani when it imposed an 8-year sentence for the possession of a fully automatic firearm, which also resorts under the minimum sentence regime. Shongwe J.A. found that the minimum sentence was shockingly harsh. He was sentenced to 15 years. Shockingly harsh, and I'm going to tell you now why he found that, because of the facts of this particular case. It found that the minimum sentence was shockingly harsh and disproportionate considering the facts of this case. The unique facts of the case were that at the time when the rifle was found in the appellant's house, he had already been incarcerated. The rifle was not loaded. I want to pause there. The rifle was not loaded. It did not have any ammunition in it, and no ammunition was found. It further had not been used in the commission of the offenses for which he had been arrested. The appellant had failed to proffer a reasonable explanation for the possession, save for a bare denial. I'm going to explain to you why this case is very similar. He had it for a very short period of time. In this case, it was a fully automatic firearm because it was a rifle. This one was a semi-automatic rifle. But this one, in this case, had ammunition in it. And the facts you referred earlier to, first I want to hear your comment on that, and then I will get to the actual facts that you referred to. Do you have any comment? Is it similar to the situation?
Part of it would be to understand how he got hold of the rifle, what was the purpose of getting hold of it, how did it get, it was a really short period of time, but it was in his possession, so it probably stayed there while he was in prison. So although there may be similarities, if you look at the whole situation, it is not exactly the same.
Emphasis on having it for a short period of time. Is that correct?
What was the period? Is the short period a month, a minute?
I'm going to assist you now. I'm going to go to a next case where they actually indicate how long the person had the firearm in his possession, which similar sentences were imposed. Where did you get the facts of this case? Did you follow the case? Or how did you manage to get a hold of the facts of this particular case?
So part of it was looking at the videos. I've already done most of my reporting. I've got the copy of the judgment, but I've scanned through that as well. But prior to that, I looked to listen to I looked at the YouTube videos.
Advocate Sisa, the witness is speaking directly at you, and
Sorry,
it's
Your Worship.
it's impossible to hear. When you say how did you get hold of the facts of this, you're referring to the matter before court, Advocate Sisa? I'm not.
That is correct. I'm referring to this particular matter, this case that she's testifying.
What I've heard is you got it from.
Initially, Your Worship listened to the YouTube videos. I was almost done with the report when I got the copy of the judgment, so I've really scanned through it, but most of it initially was through the looking at the YouTube videos.
Thank you.
You refer to one spent cartridge. Are you referring, when you say one spent cartridge, are you referring to that he only fired one shot? Or are you referring to the fact that he was convicted of that one?
That was what he was charged of and convicted of.
Where you've seen the videos, that's correct?
Correct.
You are aware that he fired actually with two different firearms, and with the one firearm, approximately 14 to 15 shots were fired with a handgun, and then with the firearm, the other one, the rifle, 7 shots were fired. Were you aware of that?
I saw the video where the celebratory shots were fired, Your Worship. There was no other charges relating to a firearm related to this matter, so I focused on the charges in front of the court in this matter. If there was anything else, to my knowledge, there was no charge relating to that.
The evidence, both videos went in, the evidence showed that he fired with two firearms.
Was, and it's perhaps, Your Worship, not for me to ask questions, but I can also not recall that there were ballistic evidence linking the other firearm to the accused.
Regardless, you saw the video, more than one shot than the one. Is that not so?
That is correct.
Your report Did it only focus on the one shot that was fired, or did you look at the totality of the shots that were actually fired on the day in question?
I considered that shots were fired for celebratory purposes and that it could have harmed people around the environment.
So I'm informing you now, it's approximately 22 shots that were fired. Would your report still have been the same, regardless of the number of shots that were fired?
It would still be the same, considering the other factors that there was no evidence further that that there were any harm done to property of people or any complaints from people around. If they were, it would have been different.
Have you noticed on the video that just prior to the accused, when he started the firing with a rifle, in fact, when he started firing with a handgun, there were 7 people standing there in the direction that he was firing to, and they were running away, or despite him disputing that.
Your Worship, the video wasn't very clear. I haven't noticed that.
If you were aware of that, would you have considered it and put it in your report?
That some people were scared. If there were evidence in that regard, I would have considered it, yes.
Yes. But you did not notice that, in other words, you did not consider it.
And there were not evidence in that regard that for what reason the people ran. I don't know what the reason might have been. It could be that they were scared. It could be for other purposes. I don't know.
It was very obvious, ma'am. You didn't see it. It was very obvious why they were running.
It would be a consideration, but part of that, again, would be coming back to the considerations in terms of that's the potential harm, that people could have been harmed, that people were scared. But the actual harm in the end, Your Worship, is that there were no injuries and facts which would have been a much more serious consideration and contribution if there were actual harm.
According to the accused's own evidence, there were about 20,000 attendees. Some of them were just standing right there in front of him during this incident, prior to him firing those shots. You saw that on the video.
It was a big event to my knowledge, Your Worship.
Have you factored that in into your report, the fact that there were actual people right there and the 7 in the direction that he was firing shots at?
Unless I've misunderstood, my understanding was that the shots were fired in the air and not at people directly.
I'm no ballistic expert, but the expert did testify what goes up must come down.
Correct, Your Worship, but there is a difference between firing in the air and it comes down. The potential is still there, the risk is still there that it can cause damage, it can cause life. But the risk is different when I fire and it is going in the direction of someone.
I've just said to you, there were 7 people standing towards the direction, despite him firing in the air or not, towards the direction that he fired the shots in.
Your Worship, my understanding of the direction is, do I fire it directed at the people, or is it even I'm directing at Your Worship, but it's still fired into the air? And if there were ballistic experts indicating the come down would have been on those people, it might be different, but the fact of the matter remains, whether it is the people in the stadium or whether it's the people of the neighborhood, when it comes down, people could have been hurt and people could have been killed, and that remains serious.
Are you aware that the Sisa Dukashe Stadium where the incident occurred is in a very condensed, right in the middle of a community, very condensed community, right outside, it's houses right around that place?
I I'm sure there were people around because the charge sheet were also very clear that it's not only the people in the stadium, but also the people working there, the supporters, the people from Beer House, and the people from the Mdantsane community that could potentially have been impacted by that.
Did you appreciate the nature and the danger that was actually present at the time when the first shots were fired? The possible harm to others, the degree that harm could have caused if somebody did get injured.
I did indicate in my report as well that as part of the seriousness, not only injured, it could have resulted in the loss of life. It is serious.
So no thanks to the accused, that it's fortunate that nobody died.
I agree, it is fortunate that nobody died.
After now sketching the scenario, do you still maintain your report as to that he should either pay a fine to a gun, NGO, gun-free, NGO, and so on?
Your Worship, when I look at the scenario and the charges collectively, the accused acted negligently and didn't consider the risks, as was stated. There were no harm done. If there were harm done, yes, I would have considered it differently. The potential harm was there, but no harm at the end materialized. The act was still negligent in causing the potential harm.
Negligent or reckless?
Reckless as well, the charges stated.
I'm going to go to page 15 of the report, not your report, the one that I've handed in, because we are discussing cases of a similar nature. I'm going to start reading from paragraph 2 of the document, page 15, Your Worship. It's referred to as a Swartz case. The reference is there. At the footnote, the appellant was convicted on 2 counts of the unlawful possession of a semi-automatic firearm. The court confirmed the minimum sentence of 15 years on 1 of the counts, in view of the fact that the appellant had offered a denial of possession, which denial was found to be false, and furthermore, that no mitigating circumstances in relation to his possession could be inferred. The court held that there was nothing to place, the court held that there was nothing to place his unlawful possession of the firearm in a less heinous light than that which motivated the lawmaker to lay down the minimum 15-year sentence. However, on further count of the unlawful possession of the semi-automatic firearm, the appeal against the minimum sentence imposed was upheld and replaced with a sentence of 7 years imprisonment. In this regard, the court held that the state accepted the appellant's version to the effect that he fortuitously came across the firearm in a rubbish dump and was apprehended the same day. The appellant's decision to take the firearm into his possession could be regarded as having been made on the spur of the moment. Spur of the moment. Furthermore, it found that the appellant did not have the firearm in his possession for a very long time before he was apprehended. The court held that the circumstances of the crime were such as to make a sentence of 15-year imprisonment disproportionate. In other words, he got 8 years. Also had a firearm in a very short period, semi-automatic firearm, didn't use it in any offense, and so on.
And the other count?
The other count was, one was upheld, one was set aside.
So Were there two firearms? I'm just trying to understand
Yes.
the context of the...
There were two firearms. The one he was sentenced to 15 years. The one of the firearms were reduced. The one that he actually found in the rubbish dump. So it was a spur of the moment decision by him. Wasn't he hadn't have it for a long period of time. Still, he got an 8 years direct imprisonment. This case, the accused also did not have the firearm for a long period of time. It's very brief. It doesn't change the fact that he was still sentenced to a direct imprisonment. What do you have to say about that?
Your Worship, what I hear is, again, different circumstances, although it was also not for a long period of time. It was, I wouldn't know why the reason is why it was picked up in the spur of the moment time, but I also hear that it was not the only firearm that was possessed illegally, which makes it different, and the use. I'm not sure whether the other firearm was used, but in combination, it was always good to look at it in the circumstances in total. But I hear what was said. But for me, the circumstances, again, are different. I'm not sure whether it was an illegal firearm, whether it was seized to the state, what happened to it, which may also make it different.
Did you come across any case where, like such as this, in the firearm-related case, possession of firearm, where an accused was not sentenced to direct imprisonment, and actually he got given a fine and to pay to NGOs and so on and so on?
As I said, I haven't come across, Your Worship, to any case where a charge was laid and the firearm was used for celebratory shots.
Have you come across a case where an accused was convicted of being in possession of a firearm, whether it's for celebratory purposes, whether it's just social, whether whatever reason? Have you ever come across the case where an accused was not sentenced to direct imprisonment for being in possession of a firearm, whether it's for just for a minute, for 10 minutes, for 20 minutes?
Your Worship, I have not, because most of the cases that I've seen were also not only the firearm possession case, but most of them relate, it's in the context of other crimes that were committed with a firearm. So the possession forms part of that, and then a sentence of imprisonment is also imposed for that. I haven't come across a case where it was purely just for the possession of a firearm.
Thank you for that submission. But in this case, other crimes were committed, shots were fired, reckless endangerment, you saw the different charges, failed to take precautions and so on. So isn't that basically what you are saying?
So, Your Worship, if I refer to other crimes committed, I refer to some of the cases that may have taken it on the spur of the moment, but it is usually taken for the purpose of committing other crimes. And when I commit other crimes, it's violent crimes like murder, robbery, and in that context, you get the sentences being imposed. But I couldn't find the case where it was done and imposed outside of that context.
So the point I'm trying to make, how would that be fair to these accused that I prefer? I don't want to go through all the cases. I just want to go to those who are closely related to the accused. How would this be fair to the other accused who have been these sentences being imposed, but in this particular instance, because the accused standing, he must now get the recommendation that he pays to NGOs and so forth?
Your Worship, the recommendation is not because of the accused standing. The recommendation is because of the very particular case that is different, where there were no other crimes committed in the sense of violent crimes. There is indications, I've mentioned it in my report, where part of the motivation to bring in minimum sentences for firearm-related things as well is because of the concerns with regards to the violent crimes committed with firearms obtained illegally. This is different from those matters.
How?
There was no intent to obtain the firearm illegally, obtain it from, and if I say obtain illegally, Your Worship, the accused didn't go out to get a firearm that is either stolen or licensed or unlicensed, keep it with the intent to go and commit murder or robbery or any other crime, as is in many of those cases that are stated. It's different in that context.
His evidence was to the effect that this was a pre-planned idea that this will be happening at the stadium.
The planning was at the stadium. The planning was not to commit an offence with the firearm. There was negligence in not considering the impact of that and the possible impact of those people, whether then from him or his people. But it wasn't done with the intent to keep it and to go and commit the violent crimes which inspired the extension of the minimum sentences regime to automatic and semi-automatic firearms.
I disagree with you, Ms. Thompson, with that sentiment, because he did commit other offences. Like I've pointed out to you, he's been charged for those and he's been convicted of that.
I do not deny it, Your Worship. I have made reference to violent crimes in the context of the minimum sentences regime.
I want to go to your report on page 33. I'm going to go to paragraph 87 on your report, where you say, although not part of the sentence, any form of pain or discomfort an offender suffers as a result of committing a crime can be seen as punishment and moral retribution. The following is noted. The lapse of more than 7 years between the commission of the offense, the conviction, and all that. You are referring now to. I just want to point out to you, those gentlemen, the cases that I referred to you, they have committed the crime and they are doing, or they did do the time. So now you're saying because the trial was delayed, and do you know the causes of that delay in the 7 year period?
I do not know all the causes of the delay, no, Your Worship.
Let me tell you, the accused wasn't immediately charged after the commission of the offense. There was an investigation that took place for a long period of time. The accused was sent with a summons. I'm not sure when was his first appearance. I speak under correction. I think it's in 2020. I just need to have a look at the charge sheet, or 2021. But during those periods, it was COVID. So the cases couldn't really proceed. It only started after COVID eased a bit up. And the trial has been running ever since. The reasons for the delay is that we are not always all available at the time, especially counsel is very busy. So how did that factor into the fact that you are saying it's a 7-year delay, whereas it's not really a 7-year delay, as I've just explained to you?
Did you just say how I worded it? I indicated that it was a 7-year period from the commitment of the offence to the conviction, including all those things for the thing. But irrespective of the reasons, the reasons why it was a delay, it doesn't mean there's not an effect on a person, and that is what I was highlighting. That lengthy cases or cases that go over a period of time can impact on a person, which is just a consideration.
You also referred to the humiliation suffered in public and by the fact that he actually appeared before court and so on.
He was convicted by the court and the humiliation comes from that.
I can't hear you, sorry, ma'am.
Apologies, Your Worship. The conviction comes, the humiliation comes from the conviction. He was convicted of a crime, and a person in his position where he also would want to encourage people not to commit crime, young people, it impacts his credibility to do so.
Did you take into consideration the fact that he was actually the author of his own misfortune the moment he decided to take that firearm and fire those shots? In fact, firearms and fire those shots. He was the author of his own misfortune, so how must that now be beneficial to him? How must he benefit from that?
Your Worship, and that's exactly why I have mentioned that it is as a consequence of that action that you take that certain things happen that impacts you. It may not have been intended, but and that is the moral retribution. It is a consequence of your own actions. It doesn't deny the fact that there were an impact on a person, and that would go for any other person in a matter that one would consider as to what was the outcome, the combination of the circumstances, looking at the person and the case.
You also said that also one of the reasons is that the accused wife and his children and family might suffer financially because the wife is a stay-away at-home wife. She basically received an allowance from him. That is also part of the considerations that you have taken into account. Is that correct?
Your Worship, what I have indicated is that when imprisonment is a consideration, there are implications. When we remove someone from society, it has a ripple effect not only on the family and immediate people, but also on society. And it is part of the personal circumstances of the accused that is considered in the trial of them.
You does reside in Sandton, is that correct?
That is correct.
Have you ascertained his financial incomes, where it comes from, and how is he able to support, apart from his 1 point salary? I don't want to mention a specific amount, 1.5 million?
Your Worship, I did not. If it was a case for fraud, there would have been a much stronger focus on assessing the finances and how these things work. Irrespective of the financial status, he currently earns a regular income, and when that is removed, it has, I didn't say they would be homeless or anything like that. The reality is that when a person, an income earning person, is removed from the family, it has an impact on the family.
Do you know where he got the 200,000 rand as a donation to his school?
Apologies.
I think you said in your report he donated 200,000 rand to his former high school and so on. Did you establish where that money came from? How was he able to
Your Worship, it was not to his school, it was to a NGO society working with children that he made the donation. And looking at, in the beginning of my report, I also indicated when I delved into certain things, it looks at how is it related to the case, the finances, how it would be related. So on a matter of confidentiality, if I explore everything that is out there, which is not really that relevant to the case, it goes on to soliciting information that is not really needed for what I want to do, which would be not a correct way to go.
should you not have, because there's now, in this instance, there's a real possibility that the accused might go to prison for a quite substantial number of years. So should you not have investigated that issue, since you have brought the family needs and so on into the occasion?
Your Worship, that is the consequence of imprisonment for any person that gets sentenced to prison, that there is an impact on the family. For some it would be worse, and for some it would be others. And the important fact is to highlight that there is an income loss and there is a possible impact on the family from that perspective. So it may be worse for some families than for others, but it certainly impact the family and their way of living.
The age of the accused wife, have you determined that? His wife? How old she is, and whether she is employable should the accused not be around?
Your Worship, that is in my report. I have indicated that she is currently a full-time person, but that she is, that her career, she forced her career to look after the children, and that she also prepared herself to be into the career. And listening to the question, I never said that they would not be looked after. I just said that there would be a financial impact on the family.
Why did you not say that they will not be looked after? What do you mean by that statement? I need you to clarify that.
So, coming back to what I said previously, Your Worship, depending on the family and their circumstances, the impact financially on certain families may be more devastating than on other families. But there is no situation where there is no impact if a person who is the main financial provider at the time is removed from the family.
I want to go now to the issue of remorse that you refer to it in page 19. Is it correct that the accused is not remorseful for his actions? He's not being taken, he has not taken responsibility for his actions. What I want to put you is remorseful that he got caught on camera.
Your Worship, I did not say that the accused is remorseful. I indicated that he maintains his innocence, which is often seen as an absence of remorse. What he does regret, though, is the consequence and the outcome of the situation that people see, may see that he encouraged reckless use of firearms. But I didn't indicate at all that he said he's remorseful for what he did. He regrets the consequences.
Yes,
and there's also a difference between regret and remorseful.
Is remorse not one of the factors that should be taken into consideration? In fact, a very important factor when it comes to rehabilitation and deterrence and so on.
So, Your Worship, when it comes to remorse, and it is usually not, when a person is remorseful, it is considered a mitigating factor. When a person pleads not guilty, and because of that, it's considered not remorseful, that is not necessarily an aggravating factor. But when it comes to the link between remorse and rehabilitation, it is, from my experience of working with offenders, and specifically people serving custodial sentences, it is not correct to say that a lack of remorse by pleading not guilty at sentence is an indication that a person cannot be rehabilitated. Your journey that you will walk with that person is different, and it's really based on a very basic principle of social work, that when we talk rehabilitation, you always start where the person is. And if the person says not guilty, he doesn't, he's not remorseful, if he's not guilty, that is where you start, and from there you look at your rehabilitation journey, but it's not an indication that a person cannot be rehabilitated, because when it comes to a plea of not guilty, for that purpose there could be various reasons for it, which is not always known at the time. And I think a very good reason, or very good example recently also within the prison was in terms of the murder of the late Mrs. Marika de Klerk, where the person convicted of the murder has been seen as very unremorseful. He pleaded not guilty. Later, as of recent, there were indications in the press where he came to the court to say he actually did do it after denying what was the reason for not guilty, and that is part of the journey. So it doesn't mean a person cannot come to that insight, it doesn't mean a person cannot be rehabilitated.
He said he was embarrassed because he and Mr. Clark were so close. She really, really liked him, apart from the other security guards. That's why he felt so embarrassed. That's the reason why he said he didn't want to admit to that.
Correct. But to my point, Your Worship, is that there are various reasons why it could be. And at the time, if one would have spoken to him, he would also not have mentioned that he would have denied his guilt, and there are very different reasons. And when it comes to, the point is again, when it comes to rehabilitation, the fact that the person does not accept responsibility, does not admit guilt, does not mean a person cannot be rehabilitated. Although in the matter of this accused, I've indicated that rehabilitation wouldn't be a primary focus.
In this case?
In this case.
In this case, the accused was caught. You looked at that videos. You saw it. Yet, he's still denying it.
Correct. Correct, Your Worship.
So from what you've seen, those shots were indeed fired, correct?
That is correct. I do not deny the court's verdict and that the accused is guilty. What I am saying, looking at all the circumstances, when I look at rehabilitation, that would not be a main consideration in terms of sentencing.
Where's your practice situated, Mrs. Thompson?
In Johannesburg.
How many consultations did you have with the accused prior to you compiling this report?
As indicated in my report, Your Worship, I had 3.
Where did these consultations took place?
The first consultation was at my office. I arranged a consultation at my office. The second consultation was at the offices of the EFF, and the third consultation was at his home in Polokwane.
The first consultation, how long did that take?
It was probably about an hour and a half.
Would you consider that enough time to make a proper assessment of the character of the person that you have seen before you, especially in the light that he was basically a stranger to you?
Your Worship, when we do these assessments, it's a combination of sources that we put together. Part of it is the consultation with the accused, and then it is consultations with collateral witnesses to obtain additional information and to also confirm information that you've obtained. And we would, from my perspective, I would never do one consultation only.
I'm going to get to the collateral sources. You are jumping the gun. The question was that sufficient time, an hour and a half, to make an assessment of a person who just arrived in your office? Basically, both of you are strangers to one another, and he knew exactly why he was there, that you have to draft a report, hoping probably that you'll draft a favorable report. The question is, was that sufficient and adequate time?
Your Worship, no, it's not, and that is why an assessment is not done on the first interview only. The first interview usually focuses on starting to get information, get to know the person, explain the process, explain the expectations, and to explore other information and resources that I might want to speak to.
So basically just getting a little bit of background, like when you go to the psychiatrist's office, basically they want to know who are you, where are you coming from. Is that?
No, it is a very structured approach in terms of what information you are looking for when you start, and then in the subsequent interviews, obviously you test information, you build it, you get all the bits and pieces of the information.
Please share. You said structured approach. We don't know what that approach is. Can you explain that?
So the structured approach would be to determine beforehand what is the information that you would want to have and what you would want to obtain in the first interview. It's
Sorry,
just sort of given
Mrs. The chair there. No, it's not you. It's the sound in the court isn't good. So there was a squeaky sound, and that caused me not to hear. It's not a problem. It was just in the beginning. No problem. Thank you, Mrs. McLean.
Sorry, Worship, and I forget to turn to your Worship.
No, it's fine. If you can just start with, you said the structured approach.
Is really to have a layout as to what is the information that I would require at the end to do my report, and what should happen in the first instance, because it is important that the person know what is expected, how the approach will work, and what information I will have, and whether there are other people I would want to speak to. And then in terms of the approach, it is done through questions, but not questions in the sense of interrogating a person. It is really a discussion around that questions that generate discussion to get information, but also to get an idea of how this person operates, how who it is.
In this instance, what happened? Because you are now describing the general practice. In this instance, what was your aim? What did you do with the first consultation?
My aim was to explain to the person the process. My aim was to obtain information in terms of starting with the process, information in terms of his life, where he's coming from, his background information, and further to obtain information in terms of who are the people that I can speak to, that he can give me the contact details. I would like to speak to his wife. There are friends or colleagues that I would like to speak to. Who can I speak to? And that is the standard approach that is followed for all other cases, and that is the aim of that section.
So in other words, the information that you got who to speak to, which collateral sources to speak to, you got from the accused. Is that correct?
Your Worship, we always get it from the accused. We can ask specific questions to help in selecting the people we can speak to. Because yes, it need to be people that is familiar with the accused, that know the accused, that will be able to answer and speak to the questions that we may have. And yes, so we always do that with the input from the accused.
And the people that he gave you, it's basically his wife, you said? His two employees, the names?
I always speak to a partner if the person is in a relationship. So that was my question, my ask. So I need to speak to your wife, not he gave me to say speak to my wife.
Okay. The other two, what you said was his friends?
There were two that were friends, that know the family quite well, that also grew up with him from, so they're coming from the same environment where they grew up, who's known him since childhood.
And two of the employees?
Two of businesses that where he is involved with, that he, yes.
They rely on him, those two?
Those two people actually, I met with my visit to Polokwane. He didn't give me the names, but because I met him, I also used the opportunity to have a discussion with him to obtain information, to check information, and to verify some of my information. So, no, the names didn't actually come directly from me. It was an opportunity that arises.
Yes, but they are employed basically for him, or by him, right?
They work with the businesses, yes.
Yes. I'm sure they must have glorified him because they are dependent on the accused, those two that you spoke to. Is that correct?
Well, my experience was that they answered my questions truthfully in terms of how they experienced the abuse, but also in terms of general, the community. As I mentioned, I also speak to people to verify information. So some of the information I have asked of things about the community and the community where these things are, that these businesses are. If I observe something, I would ask, what is this about and how does it work? Those things also, in the bigger picture, gives you an idea of who the person is.
They would be affected if the accused is not around. Is that correct?
One can say they would be affected, but the feedback is also that they run with these businesses, so the accused is not that much involved. So in the long run, it may impact sustainability of businesses, but they can also, because of their positions, continue to run with it. So I've never received the information to say if he is not around, the businesses will go down, but rather than there may be an impact because there may be guidance required, but that they can independently run with it for a period.
The wife would definitely be affected should he not be around, correct?
Well, he is in a relationship with the wife. It's part of the support. It's not only financially. And if you remove someone's partner from for whatever reason, it always has an impact.
The second interview you said took place at the EFF's offices, are correct? You only spoke to the accused when you were there?
I spoke only to the accused. I had an informal discussion with the person who was supporting him and who was arranging my access to the building. That was an informal discussion. My purpose going there was to have an interview with the accused for purposes of my report.
How long did you spend there?
I'm not sure, but it was at least 2 hours.
The last one, how long did you spend with the accused?
Probably at least an hour.
You said 2.5. Oh, my maths. In total, you spent 5 hours with the accused, if my math is correct.
More or less, yes.
Yes. You think that is adequate time to make a proper assessment of the individual that you, and I'm not talking about constant 5 hours, as you've explained, it's an hour and a half, it's 2 hours now, it's an hour. You think that is proper or adequate time to actually say that this person is a good person, this is a bad person, when you've spent basically an hour or two per session with a particular person?
So, Your Worship, the aim of it is to obtain information about the person, where that partly comes in, but also his personal circumstances. It's not to determine whether it's a good or a bad person. It is to indicate which things are at kind of risk, repeat offences, repeat things can mitigate that, and also to indicate if there are any factors to be concerned of, to be considered. It is not to make a judgment call on the character of a person as you think of that, but looking at all these things, and that's why it's not only, we do not only rely on the interviews with the accused, and that is why it is also not a fixed session of 5 hours, but obtain information, see what you further want to know, see if there are certain things that may not make sense, speak to other people to get information, but also to validate and certain things to clarify if I have certain questions. So it is a whole process that is followed. It is not just I am meeting a person for 12 hours and I make a decision, and to base it on the information that you have to do your assessment.
I want to put it to you that 5 hours is inadequate for you to compile a report like such as this, as if you are saying that this particular person is there because you spoke to a few friends here and a wife on the other side and employees, which I do not think is the proper sources that you should have consulted other than the wife.
Your worship, from a social work perspective, the starting point is always with the person, because that is what it is all about. And the best way to get to know a person is through the eyes of others, because obviously you do not get information from other people prior to having spoken to the accused itself, because you wouldn't know what to look for, what to listen for, what to ask for. And similarly, I wouldn't necessarily know what is the process that a prosecutor would go through to prepare for a case. I think similarly, other professions wouldn't necessarily know the detail of the processes that we approach in terms of getting that information. And for me, I will sometimes, depending on the case and the person, because people are also different, 2 hours or 3 hours may be sufficient to get a very good idea. For other people, a longer time may be required. I will obtain and solicit information until I'm at the point that I feel what answer I'm comfortable with and I can comfortably speak about it. Until that point, I will continue to research, speak to the person or collateral sources until I am comfortable that I have a very good idea as to what I can, of the information that I've given.
What did you expect these people to say, the wife and the two employees? You wanted them to bite the hand that feeds them, basically.
Your worship, I did not expect them to say anything particularly. I do expect them to go, and I always explain that to the people as well, what is the purpose of my questions, to answer honestly and to give me the information.
I'm about to finish. You also referenced the issue about the cross-examination. I'm not sure what was your specific wording regarding his cross-examination, how he conducted himself during. I didn't get to understand what you meant by that.
So, Your Worship, what I have indicated that when it comes to the accused's motivation, the things that drive his behavior is a need to be right, to make a difference, and to protect people. So when he sees wrong behavior, he will address it, and he wouldn't hesitate to do that. And I think there are ample of examples. When he addresses an issue, when he has a discussion or a debate, he are generally able to contain himself, to focus on the matter at hand, to take personal matters aside, and to get the answers what he's looking for in that matter.
How would you describe it?
However, and that is my description. However, when it comes to certain matters that links to what he sees as right and wrong, if he sees it to be wrong, if it's a matter that he is very passionate about, respect the dignity of people and those type of things, and people touches on that or he sees it wrong, his behavior may be different, and people will see that as, and that is what I was explaining to say. He will address it as the issue. It can be seen as
aggressive. Is that the word you're looking for?
No, it's for people may see it as aggressive. It's not necessarily aggressive. It is. You will see frustration. You just need to get the exact wording. But you will receive a reaction, and he will act out. and that is what I mentioned, and that was what also was observed on the cross-examination, and it was also observed when he addressed the people after the conviction. He would make remarks that would either try to address what he perceived wrong at the time, and he would react to that, or you would pick up the frustration.
Ms. Thompson, I want to put it to you, you're playing with words in a fancy way. The accused, do you perceive him as rude after watching all that? Aggressive? Bit of a bully?
It's irritation and frustration that was coming through, and sometimes self-righteousness where he feels that he's right and it's his point and he's the one that's right.
That's your fancy way of describing it.
That is how I perceive him, and also how I've experienced him.
Lastly, I just want to go to your report. I just need to see where it is where you describe how the accused does not like noise and so on. He brings noise wherever he is, so what do you say about that?
Your Worship, I didn't say he doesn't like noise. I said he's sensitive to it. So if the noise gets too much, he will afterwards have to have a period where you just quiet down, do the things that he does to just quiet down. So he will not be the person that you will see that is surrounded by noise in a noisy space all the time. He needs some quiet time as well. And you didn't say that he's noisy. You did mention he was bringing noise. I'm not sure what that means.
He himself is noisy. Would you not agree with me? When he does do what you said, just describe. At the speeches, you said outside, after the appearances, and...
When I say noise, it is noise in the environment where you live. And in that context, I have put that context within the context as to where he was growing up. That was a small house with many people with a lot of noise. So when he's in his living environment and there's a lot of noise, he manages in ways to reduce that noise. And without going too lengthy into the theory, but quite often things that might trigger us, that we struggle with, comes from how we grow up or experiences that we have. So when it's in his home and his environment where he needs to recover, perhaps after a noisy day as well, he would prefer a bit of more solitude and quietness.
That you could have fooled me. It just proved my point that you did not have adequate time to assess the accused in order to come to such a conclusion.
I'm not sure what is meant, so I cannot comment on that.
Thank you very much. I've got no further questions for this witness. Thank you.
Your Worship, the re-examination was done by my colleague, Mr. Mdantsane.
Sorry, I couldn't hear. The re-examination by... Just a minute.
Thank you, my lady, and thank you for the opportunity. You heard that the trial took over 7 years. It's day number 1 to me, and only 4 hours. So I still have a lot of catching up to do. The accused instructed me to acknowledge the members of parliament from different political parties, the traditional leaders, the religious leaders. Yes, it's helpful to always bring a junior along into a case. Thank you. The students and the general members of the EFF and members of the public who are present in court. Perhaps that is where we should start in the re-examination. because your report references the impact of the accused, the positive impact to the general South African public, and the consequences of removing him from playing that positive role. You reference that in various parts of your report. Can you just expand on that? Because sometimes it gets missed in these accusations of Mr. Malema being noisy.
Yes, Your Worship, and that was part of the consideration that the society was a contribution in that to the community. Apart from serving in Parliament was it's a concern for the community and the activities that's important to me. I have mentioned, for instance, coming back to living by what is important to me as well. The dignity of people, for example, is very important to the accused, and part of that links to the living circumstances. So when I was in Polokwane, I had the opportunity to visit. We did a quick visit to the shared community, and it was, I observed how clean the community was. And when I asked about the reasons for that, it is because it's one of the things that's really important to the accused. It is the need that was there for the supervision that is run, but the detail to what is paid attention to is, for instance, the time of the supervision. That must be at 1500, considering that you may be kids going to school without having any food. Not all the schools in the community may have a food service. And if it's at 1500, they can either have an early lunch or a late early dinner or a late lunch, but at least they would have food to give them the strength to continue with their work after school. So it's these considerations now in terms of the contribution to the community. And then a part of it is whether people agree with these views or not. There is a community that subscribes to his beliefs and see him as a leader, and he is a voice to those people. A big portion of them but he continues to be a voice and to drive and try and change things for those people who have not seen the change they expected after.
We'll come to that second part, but just to deal with the first component where you said he grew up in economically challenged circumstances. Even that is sometimes difficult to understand what it means. But let me ask you just basic questions. Who raised you?
So in terms of the, he was raised by his mother, but also supported by the grandmother. It was a single parent. The family did not have means, so and there were many people living in the house with limited means, so they had to share from a very early age the limited resources that they had.
And where was his father?
He doesn't know who his father is. His father has always been absent. I think his search for who the father is by asking the mother and grandmother didn't give any answers, so he still does not know who his father is. He grew up without his father.
Sorry, Counsel, I don't want to. Can you just clarify for the court how is this emanating from cross-examination? Because you are introducing new evidence now in re-exam.
It is in the report.
It's in the report.
Yes.
It's not emanating from cross-examination, which the purpose of re-examination is.
Well, my lady, it does emanate from the cross-examination because especially the last questions that were asked about the personal traits and the personality character.
I don't have a problem. I fully agree on that. But you are now asking about the father. So that was in evidence in chief, not mentioned during cross-examination.
No, my lady, the only reason this is very crucial is because if you recall, when the witness responded to say what are the trigger elements to Mr. Malema, he said it is the circumstances in which he was raised.
Yes.
Yes. Now, I'm asking, what are those circumstances in which he was raised?
You asked where is his father. So then you must phrase it in a different manner so that it forms part of cross-examination.
I am totally happy to rephrase it as opposed to saying where is, I'm not saying where is his father. I'm saying when he grew up, what were the circumstances of growing up?
That's a different question if you rephrase in that way.
Very happy, my lady, to rephrase it that way.
Thank you.
Can we then go back to this point? Because you mentioned that he has particular triggers that explain his behavior. Remember that he's being accused of being a bully. He's being accused of being aggressive. He's being accused of being loud, of being noisy. And then your response is you have to understand what made this man. And one of the factors is his upbringing. Expand on that.
So the upbringing was in poor circumstances. A number of people sharing a small house. Influential people with his mother and his grandmother. His mother had received a grant. His mother was a domestic worker, so the income was low, and some of the aunts had from time to time positions. Had a grandfather at his birth. He never knew the grandfather. He left the family, and he never knew his father, so he also grew up without a father figure. And very poor circumstances, and then at a very young age he became involved with the teaching through the young pioneers of the ANC. A better future, different circumstances of vision should the apartheid regime come to an end. So, sharing with people, fighting for the poor, things that have, and growing up as well, the community, the focus on the community, both his mother and grandmother, despite the circumstances, had a strong focus on the community. That continued, and that is part of the things that drive me to be a voice for the people who are poor and disadvantaged.
Thank you very much. You then said there is a second component, which is his aversion to perceived injustice. Can you just explain that, which also drives his behavior that people may perceive as aggressive?
Part of that, again, comes partly to his personality profile, part of the upbringing. It is, and in terms of his profile, what drives him is looking at the world as a place where things are not always right and having to work to make the wrong right. And that drives a lot of things. And that is really to just give an understanding. I've also said in my report, this is used for coaching purposes to help people develop understand where their behaviors and things come from. So it is really that need to make things wrong. And looking at his whole history, the exchanges he expected, the experience he's had, when it comes to injustice, he will perceive it as a wrong that will drive him to try and prevent it.
Thank you. And the allegation that he is a bully, how did you perceive it as a person who's actually studied his personality?
So when people are out there, we can put different labels on their behavior in terms of whether it's bullying, whether it's aggressive. It also depends on how we perceive the information. So what people see and how they see it is different. They see the frustration, they see the irritation, they sometimes see the self-righteousness where he believes that he is right, although he might not be right. But that is what people see, and when they put labels on it to bring it to how we want to explain it.
But what is your own opinion as a person who studied his personality?
So, in terms of my experience of the person in my work with him, I have, as I've mentioned in my report as well, I have experienced him to be really approachable and forthcoming with information. There were no restrictions on what I could ask or not ask. If there wasn't, if I didn't agree, he would tell me about that, and we would discuss it, but I've never experienced it like that, which is different from the profile that people may see. But yes, the point is still that I've mentioned, if he sees this injustice or he is perceived to be wrong, he will react, and it will be an emotional type of reaction that can be seen as the source of it may be frustration, that it can be seen as rude or aggressive, how people perceive it when he reacts.
Then these two aspects, which is his concern for the poor that is informed by his upbringing, his aversion to injustice, how do you think they will play out in the sentencing, which is what these proceedings are about?
Your Worship, I'm not sure I understand the question.
Yes, but why are they relevant for her leadership to take into account in sentencing?
So, if I put it all together as a thesis that I've considered is, he's a voice for the people, yes, and he's serving the community. So if we then look at the custodial sentence, we don't only take out of the equation a family person, but we also take out the person who dedicated his time, who is dedicated to the serving the community, which impacts society, and that is really the link about it, is to fight for the poor, for justice, and to make a difference in society. And if we remove that, the people supporting him, there's a void in terms of their voice, and the projects where the community, all these efforts are put to make things better for people, may in the end not be sustainable.
Yes, thank you very much. I just also want to close this part by dealing with the criticism that 5 hours was too short. My understanding of your response is that when you are doing a personality assessment of this type, it's not just the accused, it's the accused and other people who know him. It's the research on publicly available sources. It's the compilation of the report, and then it's further engagements with the accused. Firstly, am I correct in outlining those steps as being the actual sources of the report, not only the 5 hours?
Your Worship, that is correct. It is an approach of getting information, verifying it, and getting it from different sources. Sometimes when you look at sources to verify the information. So it is a combination, and I just want to add that it's not necessarily about assessing the personality of the person. It is about looking at the behavior, looking at all the circumstances of the person, and how that impact and how we look at that in the context of the crime, what could have contributed to it, or also in terms of the society, how it would impact society. A person gets released in society or go to prison, and that is where the combination of everything comes together when it comes to the sentencing recommendation. It is really looking at all of it, but in assessing it, it is a combination of speaking to the person, speaking to other people. If I can give an example, when I received information about the soup kitchen and some of these things before I had the opportunity to go there, I did a research to see what can I do, does these things really exist? Is there a pilot program? Did anyone ever qualify from it? And in that search, I came across to see, okay, they also donated to the Sisa child welfare. No one disclosed that information to me. I came across to public sources while I was validating other information that I obtained.
And so the correct way of assessing it then is to look at that period in totality.
It is to look at the person in totality and the life up to now, and working also from the premises that who we are now are influenced by what happened in our lives and the decisions we made as well.
So it's really the quality, not the quantity.
Yes.
And also just to deal with the quantity problem. I mean, when you look at everything you've done to compile your report, can you give a sense of how many hours you've actually spent? Or weeks, or months?
So as Your Worship, I started off first, before I even started off with the videos in the case, I asked for a copy of the docket, so I went through that to give an idea of the evidence and what were the statements and things like that. That took quite a period of time to give a bit of context. Then, because of the accused profile, there's a lot of information out there to get an idea. I think there's some of my things, so I also spend a lot of time listening not only to the court proceedings but also to YouTube videos where the accused would, address his supporters. I also give there some information in terms of his stance against anti-bullies against drug and alcohol abuse. Work from those type of information, not necessarily something from the government, and if they have, I will look for information to verify. So it's difficult to put the time on it. When I start writing the report, that's probably the most time-consuming part, because I write something, I wonder about it, and then I wonder whether there's really supporting information to that. I will look for it. I will sometimes speak to someone, or I will search to see whether it is a process. And the purpose of the collateral interviews, apart from getting additional information, is in essence to verify the information that I received from the accused and his wife usually, but also speaking to the wife who repeats the things, and they would confirm the information that they obtained.
Can you assess the total number? I mean, the thing that stuck with me during that part of the exchange was that 5 hours is too short.
5 hours with the, yeah, I've spent about 5 hours with the accused. With all the others, would at least have been another 6 or 7 hours. That's excluding the research and the reading and obtaining information.
And when you add all of that in totality?
If I can exclude the writing of the
No,
report.
include the writing because it's part of your assessment.
It's probably in days, probably about 12 days.
Thank you very much. Now, you also were taken to task about the distinction between what the video shows versus what he was charged with. And you seem to take the view that what's important for you is what Mr. Malema was charged with. Can you just explain that distinction?
Part of that, Your Worship, is, and again I'm coming back to the profile of the accused, there is a myriad of information there, and it's very easily to bring in things that's not part of the case or that it's not in charge of, or any other matters that he may be in, and then it derails, I think, the process, because like with any other case, the purpose here is to bring the personal circumstances of the accused to the court and to look at this particular matter. But because of its profile, and I think that also added to the time I've spent, is to see what would be relevant here, what is evidence, and there may be other cases, but is it relevant to this matter, and how do we focus on this matter and not bring in additional things that may not be as relevant to end up with the aggregation.
Thank you for that. Now, there has also been a suggestion that these reports, in other words, reports similar to yours, are a product of a cut and paste. Now, no evidence was produced that your report is a product of a cut and paste. But nevertheless, the accusation has been made and thrown into the air. Can you respond to that?
Your Worship, personally, I have a thing about cut and paste, but when you look at the report, there are also similarities that can create that impression. So if I have referenced a specific book, I may bring it into a report. I may not necessarily do a cut and paste, but that you will see certain things in where it's relevant from one report to the other, where I quote theory or where a specific case, it's similar cases, and you refer to a case law, you may find those. But other than that, it is every person's story is unique, and we need to represent the uniqueness of every person's story. And as I said, from a personal point of view and how I approach my work, and people working with me know that I have a thing against copying and pasting, which is very good.
But if we are to answer this particular report, is this a product of a cut and paste?
No, it's not.
Now, a lot of time was spent on the cases. I just want to do that exercise because there were 2 or 3 things that needed clarification. To start at page 40, of your report. There was confusion in the cross-examination about the relationship between page 40 and page 41. Can you just clarify that first?
So page 40 was really a few cases that I've indicated to say that when you work with cases, irrespective of the series of crime, there are sometimes exceptions in terms of the circumstances and also the circumstances of the people involved, the accused. The page 41 is really cases that I was looking for to see whether I could find any indications on sentencing relating to discharge of firearms, the reckless behaviour associated with it, to assist in the absence of haven't found anything specifically for the discharge of firearms in the laboratory instance. So it's really just a list of the cases to say, I have looked at these.
Now, there are two cases I want to reference at page 40. The first one is the third case of Akko. Remember, you debated that at length with the cross examiner. And he expressed the view that the fine of 50,000 rands appeared to be rather light considering the offenses. Can you just respond to that directly?
Your Worship, when it comes to determining a fine to respond to severity, and I've also indicated at the end of my report, that the sentencing still rests with the court.
Yes.
And that the court determines, based on the information I've provided, whether it would be suitable and what would be suitably severe. It is not something that I would propose to the court. I can make suggestions as in this case, but at the end we still have the responsibility. My role can never override that responsibility, so it is a court's decision.
Because I understand you supported that sentence in that case.
At fine, yes, but in terms of the amount associated with that, I would never give an indication as to what would be severe or suitably severe, to reflect also the seriousness of the crime, balance with what the circumstances of the person.
So you supported more the principle that incarceration is improper.
Correct, yes, Your Worship.
And the next case is the case of Bezos. I think it was the case of Mr. Alexa Bezos.
That is correct, Your Worship.
And you said it was a private prosecution by AfriForum.
That is correct, Your Worship.
And the sentence there is 100,000 rands fine or 12 months imprisonment, added to a 6-month correctional supervision and a direction to perform community service. Now, is it the case that you also supported that sentence there?
A non-custodial sentence, yes. And part of the considerations there, and I know there is a big concern with regards to gender-based violence, but also referring to the article of Justice Cameron, where there were very strong sentiments that for certain of these things and violent crimes and because of the violence in prison, looking at the circumstances, sending everyone to prison, and you can often perpetuate the issue rather than make it better and resolving it. It was part of the considerations, and I have also in that case consider instances of gender-based violence and how it occurs, and statistics around it, and specifically also it is a big concern, but we want to be fortunate because also there are certain communities that are much more exposed to that than others, and how do we balance and how do we come to a solution in addressing it, and obviously there are other personal circumstances of the absence of you look at trends, there are no trends of violence in anything like that. So it's a number of considerations. It's not always as easy to say this is the case and this is the matter. When we bring in the personal circumstances, every person is different and the personal circumstances is different. And another similar case you have on the person who is incredibly violent, you have other violent who will see violence with other people. So there are a number of considerations that you need to apply. And my focus is always to bring the personal circumstances and try to relate to what happened.
Yes, I mean, the Akub case is unique in this context because similarly to what we are dealing with, it's also about a negligent use of a firearm. It is also a discharge of a firearm.
So which matters?
Akub, the third case.
Akub, yes.
But the presiding officer in that case felt that a non-custodial sentence is appropriate.
That is correct.
And similarly, in the Bezos matter, it is a GBV issue, which is a big public concern. But the presiding officer in that case also felt that a non-custodial sentence would be appropriate.
That is correct.
Now, you've explained what page 41 is doing, but I also want to do the same exercise in relation to that. So you clarified what that is doing there. It's similar cases or cases that...
Where similar charges were raised, Your Worship.
Yes. What do you mean by that?
So if I look at the first one, although it was murder, there was also a charge for reckless endangerment to personal property, for which the accused was sentenced to 2 years imprisonment. It's not similar to this case, but it is a similar charge. There was another incident. And in that instance, the person was sentenced to 2 years imprisonment.
And then perhaps the second and the third case, which I thought were probably the more on point here.
Yes, so I think similar in the way that it was the discharge of a firearm in situations that could have injured people. The difference of it is that there's no indication that those firearms were used illegally.
In relation to which case? The S versus Pistorius case?
The Pistorius one, yes, and the one that was referenced in that other matter, in the other matter was referred to.
And that's which one, the third one?
Yeah, the third one.
Maybe, Your Worship, this case will be given to you in due course. The case of South African Human Rights Commission and another versus Malema and another. If there's a copy now. I beg leave to hand this out.
At the end, we'll just mark everything that's been submitted during the evidence at the end.
Perhaps the witness also doesn't have one. I should give. I will use the. Oh, yes. Oh, no. I think everyone has it. I would like you to just read paragraph 16 into the record of that judgment.
Pursuant to this incident, the second complaint was arraigned in the Kyle City Magistrate Court on a charge of assault of Mr. Fakana, and another white male was also charged with the assault and with discharging a firearm in a public place, to which he pleaded guilty and was given trial. After standing trial, the second complainant was found not guilty on generally guilty.
Is that what you are referring to in your third column?
That is correct.
Now, if we could then go to the I'll go to the other cases that are in this article. But before we do that, I just want you to address this allegation that this whole point about a fine is tantamount to paying your way out of prison. That is the phrase that was used. The first difficulty, which perhaps you can address, is that a fine is part of the sentencing architecture of this country. It's in the legislation.
That is correct, Your Worship. I have also indicated when I looked at the Firearms Control Act, because these offences were all violations of certain sections of the Firearms Control Act, that the Act provides for either a fine or imprisonment or both.
But there is a second issue that I would like you to comment to respond to this phrase, paying your way out of prison, which is what impact does that actually have on particular biases against people that are perceived to occupy a certain level of status in society? Is it the case now that merely because you've charged a politician, a fine is inapplicable to them because they can afford to pay it?
Your Worship, and responding to that in cross-question, I think that is what I was getting across, is
Yes.
that irrespective of the status, it is still a sentence. And yes, if the means of the person is considered, one would say that the person with the means to do it would get a higher sentence perhaps. But I wouldn't think it would be a matter of the status of the person would depend on whether you're eligible for a fine or not, but rather the legislative structure and the personal circumstances and the facts of the matter, rather than the stature of the person.
So would you say that Mr. Malema's standing as a member of parliament should be irrelevant to the question whether a fine is appropriate or not?
I do believe it should be relevant. A consideration is still the impact that a custodial sentence would have depending on the nature of it. But it shouldn't be a consideration. It should be based on the impact that it would have on the community, the society, and the seriousness of the offence.
There's also another aspect related to this, which is people like Mr. Malema can afford to buy your services. You remember that. Now, could you just deal with that, because it's left hanging, because there is a sense in which you are told people are buying your services, but when you want to disclose how much are they paying, you are told not to disclose it. And so the impression is created that you are a social worker for hire. But just deal with that, because it may leave a really bad impression.
Your Worship, like any person, professional person who renders a service in their private capacity, you are paid for your service, and that is contracted or indicated to a person upfront what it would cost, and that is what you're paid for. When I have the initial discussions and the request to receive the report, I also set the boundaries and the rules for the way I render the services, and that is that at the end when my report is done, I'm happy for people to check factual information for me, dates, those type of things, but when it comes to my opinion, it is not negotiable, because I need to stand here in front of the board and speak from the conviction that this is my true belief, and I have taken the oath to say I will speak the truth and the whole truth, but nothing but the truth, and in that accept that other people may differ from me, but it is not a service for hire, and if I understand correctly, where you can come to me to say, oh, we have this case and we want this type of sentence, can you please do the report? It doesn't work like that.
Yes. You see, the other reason I found that line strange is because the fact that your services were requested was in fact raised by her ladyship herself after the conviction, where an offer was made to Mr. Malema that the court could arrange a professional of your services to provide exactly the same service. And now it's turned around and you are being criticized, and Mr. Malema is being criticized. So I asked my learned leader to show me where this part was dealt with. It's on the 1st of October 2025, after the conviction judgment has been read, at page 38 of the transcript of that day, where Her Worship says, Advocate Hodes May I just inquire on this pre-sentence aspect? Will you be following the normal route that is followed, or will you be using your own? Then he responds, our own, Your Worship, in private practice. And then the judge says, okay. Then Mr. Hodges says, the signal is bad, Your Worship, but I've attempted to get hold of Mr. Ina Thompson, so they've known about this long ago, who does reports regularly and is qualified with an LLB and a degree in social work. She does a lot of these reports. Then the judge says, the reason why I'm asking is merely so that the clerk of the court may know whether she should prepare a request for the normal route, but now that has been ruled out and the defense will do so on its own. So this is not a special favor to Mr. Malema. This is a normal route.
Your Worship, when I took the co-respondent, you checked my availability, and I indicated that I'm available on that day. You only later told me that it is for this particular case.
In your line of work, do you also do reports for victims of crime as opposed to perpetrators?
I've never received a request, but where there is a victim, it's not society that were impacted, but there is a victim, I always reach out to the prosecutor for the case if there is not a victim impact report or a statement from the Department of Social Development. I always reach out to the prosecutor to ask whether they would be comfortable if I also include the impact on the victim within my report, all the information about this report.
So you try to incorporate it into your report?
If I do, if there is no independent statement, because it is an important part of the proceedings, and it is important that victims should also be heard. And if I am being permitted to do so, yes, I do.
Yes, because in this current report, and that's something that came towards the end of your evidence, there is no reference to victims. Is there a reason for that?
It is because there were no individuals that were harmed. So in a certain sense, one can probably view society as the victim because of the perceptions that it manipulated, but there was no indirect victim that were impacted or harmed, so that was that happened.
Now, just on this issue of money, remember that you wanted to disclose your rate and then you were told not to disclose your rate. Do you actually want to disclose your rate or not? Feel free to, because the impression is that there's a lot of money being paid to you, etc.
So in this case, I have not concluded the case yet because it is, the time-wise, it is much more than my average rate. But in average, or my normal cases, in the normal way of the run, where it takes sort of more or less the same time, I do cap it, and I also tell the accused I cap it at 15,000 rand. That's an all-inclusive rate, considering all the research, the interviews, the reports, the appearance in the court, because I need to make it, although it is a business and I need to be paid for my services, I also need to make it as accessible as possible. And then where there are requests for very specific circumstances where a person cannot afford it, I have done it to 7,500.
Ms. Thompson, if one were to ask the attorneys in this room to produce their rates, there would be a lot of embarrassment. Your rate is very, very low. Thank you. I want to then come back to the cases in this document. I think there were three that were, or two that were specifically referenced. You still have this article called A Note on Sentencing Practices for the Offense of Unlawful Possession of Semi-Automatic Firearms by P.G. Todd. So go to page 11. first case that was referred to and the way it was presented is that it is on point, not just similar but on point. As versus Asman, it's a judgment of the Supreme Court of Appeal. And I remember you constantly asking what are the facts. The facts are set out in the judgment itself at paragraph 1. And I just want to read this out for you. It's a judgment by Judge Shongo. On 2 October 2008, the appellant, Mr. Yusuf Mohammed Asma, was convicted by the KwaZulu-Natal Division of the High Court on charges of kidnapping, murder, and the unlawful possession of a fully automatic rifle, to wit, an AK-47, read with Section 51 of the Criminal Law Amendment Act. He was sentenced to 8 years imprisonment of the kidnapping charge, life imprisonment on the murder charge, and 15 years imprisonment on the unlawful possession of the firearm, and we know the firearm to have been an AK-47. The court ordered the sentences to run concurrently with the sentence imposed on the murder charge, i.e. life imprisonment. Now, just having listened to the summary given by the judges themselves, does that case bear any similarity to what we are dealing with today?
Your Worship, apart from, I think, the similar charge that is in there, I do not see it. When I would have had to look at it, there are certain things that indicate a pattern. It wasn't only one charge, there are other things linked to it. It speaks to the reasons why the court brought this into the minimum sentence, or the legislator into the minimum sentence regime. So it is different, and you can't look at it, it is also different.
Well, there's murder and kidnapping, so the possession is in that context.
And even if the other firearm for which the appeal was upheld was not linked to those, there is still a concerning pattern when the firearms are used for violent crime.
Which is the point you've been trying to drive today.
Yes, you did.
Thank you. And then there is another case, I think this one is, it's sorts at page 15, which also was cited as being similar to this case. Now, when you look at the source case, if you look at page 15, the second paragraph, are you there? Of the article. Now, there you will see that there is no actual summary of the underlying facts in the article itself, which makes us then go and find the judgment itself to see what actually was going on. Now, in paragraph 3, it's an appeal, a judgment of Judge Rogers when he was still in the High Court before his elevation to the Constitutional Court. It says, the facts and respects of counts 1 and 2 are that on the evening of the 28th April 2012, Arendse was patrolling in Pumlani in the Lotus Refuge area together with a member of the neighborhood watch. They came across the appellant, who was in the company of another man. As Arendse got out of the patrol vehicle to question them, he saw the appellant take something from his pocket and throw it over the nearby fence. Arendse searched the appellant and the other man, but found nothing on them. While the member of the neighborhood watch guarded the appellant, Arendse inspected behind the fence and found a cocked semi-automatic pistol with 8 rounds of ammunition. The appellant's version, which the magistrate rejected, was that he had been in the company of 4 other people, that he had not been in possession of the firearm or thrown anything over the fence, and that he had not seen anyone else do it. So again, just that basic summary. People being apprehended and then throwing an object to hide it. And then that object is later found to be a semi-automatic rifle. They are asked about it, they deny it. And those are the facts. Can you comment on the similarity between that case that was read out to you and what we are dealing with today?
It is, again, it speaks to the position, and that would be the similarity. But in terms of the detail of the matter, and some of the information is obviously not there when you speak to the people and the guy to be telling to the case, those things come there. But what would they want? Why did they have, even if they've been destroyed, why did they have to do it? And what was the intent with it? For how long did they have it? There's a lot of questions that I don't know, but it doesn't on face value seem.
Now, in this particular case, as I understand, those were the only two cases that were extrapolated from this article. Now, in this particular case that you were dealing with, you mentioned earlier in your cross-examination about the absence of a witness who was either harmed or scared, because there was a suggestion in the cross-examination that people could have been scared. And I couldn't work out whether there was any evidence that there were people that were scared. People could have been caught.
I haven't seen any evidence when I went through the information to my availability that indicate and was indicated that there were people that were scared and that probably running away because they were scared.
And then there was also this question around the one case you cited where someone is not shooting at a particular target but is shooting in the sky. And the purpose of the shooting is to celebrate. Now, I mean, have you found, you've done thorough research on this, any case, anywhere, closely approximating what we are dealing with here?
Your Worship, I haven't found anything, and I think that is when I started to look for other cases where I might find similar charges, because I couldn't find anything specifically relating to discharge of a firearm for celebratory purposes.
Thank you. I'm going to leave the topic on the analysis of the cases that were put to you to another topic, which is this role of remorse. I just want to understand what your evidence is. Your report says that the accused regrets the consequences and the attention that was paid to the incident, regrets the incident. And he also regrets the fact that people might think that the use of firearms is acceptable, following his example. And then you said, well, remorse does not aggravate. How do you see the role of the position of the accused specifically? Yes, the relevant parts is is page 19, paragraph 46 and 47, if you want to remind yourself.
So, as I mentioned, I don't see remorse as an aggravating, the absence of remorse as an aggravating factor, but the existence of remorse is a mitigating factor. In this instance, the accused claims that he is innocent, so I wouldn't say that there's remorse in the true sense of the word, but if one then said to say, is rehabilitation needed, do we need to convince him to be a better person? The fact that he understands the seriousness of what could have happened, even though it's not by his own doing, perhaps no one was injured, but that, and the fact that he regrets that he created the perception, which was not, he wouldn't have wanted to create, that it is acceptable to be reckless with firearms, indicate that a way of thinking that would prevent you from doing a similar thing again without having to go or consider rehabilitation to convince you that this is totally wrong and it's dangerous.
Yes. Now, you were criticized that the sentence you are recommending is just too light. I think that's really, if we had to strip all of this thing off the verbiage, say this is just too light. Okay? There is a range his custodial is suspended, so it's fine. That's arranged. I just wanted to explain to his ladyship why a non-custodial sentence is in fact the appropriate sentence in this case.
Your Worship, if I look at the detail of the case, the fact that it was a celebratory shooting, the intent was not to harm anyone else, that even the position was for a very short period of time, there was no intent to keep it for a prolonged period. Together with that, if I look at that and I look at society and I say we are removing a person from society that is contributing positive to society, that is a family person, and removing people from the family also has a ripple effect on society. So if I look at that and I look at the price society is paying for a custodial sentence, the question that I have is that's what we would gain from it is to send a message to people it is incorrect, and I know there's also views on the deterrent value of it. Does it really justify the price it is going to pay for it, specifically the people from the community and through the community initiatives and also to effect on disrupting a functioning government?
Thank you. I have nothing further. I just want to see if my colleagues feel strongly about anything else. Thank you, Madam.
Thank you.
Worship, the only request would be that the report be accepted and marked as an exhibit. That's the only request.
I'll do so now, Advocate Otis. There's just a few questions that the court would want to ask the witness about.
Thank you, Worship.
Thank you. Just keep in mind, I've not had the report since it was submitted, so it's new to me. I'm not going to nitpick, but it's the only opportunity I have to ask you to avoid having to ask you to come back. So just bear with me, please. If I am taking from memory now, you had informed the court you had spent time as a social worker and also amongst correctional services.
That is correct.
Therefore, I may assume you are familiar with, as counsel read out, the procedure the court had offered and wanted to distinguish whether the defense will follow the social worker or the probation officer's report and or correctional services report. You are familiar with those reports. In effect, it is exactly the same as what you are doing. It's just the one is the government and this you are private. That's the only difference.
That is correct.
Okay. So I don't have an issue with that at all. I also want to inform you that in this instance, as correctly said by you, the court is not dealing with substantial or compelling circumstances. It was not invoked by the state because that is now minimum sentence act. And here the state is going on the principle of 15 years imprisonment in respect of count 1 is the maximum term of imprisonment going down. So that's why I'm not going to discuss compelling and substantial circumstances. It's an academic point. With your experience and what you've drafted in this report, in short, what makes any of the facts contained here different compared to the lives of a million other reports with exactly the same contents?
Your Worship, I think the risk is the same to the injury of people, but the reasons in terms of why the firearm was obtained, if I look at the Firearms Control Act, in terms of the spirit of the act, wants to get firearms off the street that is used.
Okay, no, look, I don't think, maybe I have not been there. Let me be. What in this report that the accused comes from a humble setting, worked his way through, is now a provider. It is not different to every other person appearing in a court of law daily.
Your Worship, yes.
That is what I'm asking.
The personal circumstances of a person is it's unique to every person, but it is presented to the court in all matters.
We all agree on the fact that it's unique to a person, but what is unique in this report?
For me, Your Worship, it is more on the substance of it in terms of the contribution made to the community
Okay, let me just ask you the contribution you say made to the community, okay? Let us just stop on that point so that we don't lose track of the long sentences, okay? My question on that one would be, so are you saying to this court that if you contribute to the community, it's fine, you may commit an offense?
No, Your Worship, not at all. It is part of the considerations.
Part of the considerations.
And it speaks also to the aspect as to what are the risks of committing crime again.
Okay. Then while we're on this point, you've emphasized throughout your evidence at a direct question by counsel, why is it appropriate that a non-custodial sentence be imposed? And you replied by saying, because it was a celebratory shooting. That was your reply. Okay? So that was your reply. I'm saying to you that was your reply. Now the question is as follows. Because of the nature of the shooting, anyone who's having a birthday today may walk down Oxford Street, shoot a firearm, and it's their birthday and celebrate. Is that what you are saying to me?
Not at all, Your Worship.
Just explain the difference then, please, ma'am.
Your Worship, so what I mean is that it was used for a celebratory shoot.
Yes, as the person outside will be using it for that same purpose.
When I compared it to the other cases, it wasn't obtained with the intent to keep it for a long period, to go and commit other crimes, and to contribute to the violence in the country and the firearms that need to be...
Let us just stop there because you've answered and your answers are very long, so that brings me to the next portion of this report or your evidence, which I wanted to ask you about, which you mentioned now. It seems as if you are, and please correct me if I have this wrong, it seems as if you are contributing or attributing the shooting or the firing of a firearm that it must be accompanied with violence. Because you are referring to there was no violence. There was no violence.
Your Worship, that is a consideration, and if there were, if you look at it all together, if there were injuries, it would then aggravate the circumstances, and it would be aggravating circumstances that would inform a more serious sanction.
You see, that is maybe why I have a difficulty to follow you here, because you were saying it was a brief period of time, it was a celebratory shooting, and there was no violence, and you could also not find a similar case of this nature. Now, so what?
A similar case of that nature, Your Worship, is really to indicate in a situation like that what would have the sentence been.
Now we know there is not. So does it take away any of the charges because this is the first?
No, it does not at all, Your Worship.
So I don't understand this.
It does not take away the context and the charges.
Because I'm concerned that you are also telling this court that your client is very concerned that he has created the perception that one may be reckless with firearms and that he regrets.
That's correct,
So
Your Worship.
we are all on the same page. And as you have explained in length that, yes, every person may plead guilty. That is, are not guilty. That is a given. And remorse is not a requirement. So we are on the same page. But you say he regrets the perception. But in the same instance, it's fine because it was a celebrated shooting. So what is it that is being said here? What is the perception that we must take from this?
So, Your Worship, it was a celebratory incident, but the expected outcome is that it created the wrong impression, which is regrettable and was not intended.
The impression is that this was a planned shooting or firing at the birthday event. So what impression is it that was supposed to be perceived then? What is it being, what is the perception?
So, Your Worship, linked to the other charges, it still remains that those things were not considered and then it created the impression because the necessary caution was not applied, leading to the charges of the endangering and the recklessness.
Okay, let me leave that. I have only two aspects left. No, a few in fact, because if I had it in before the time, it may have been a different story. The other issue, not an issue, but if you can explain, I think if we go in the circle of a radius of 5 kilometers on each side of the court building, we're going to find about 4, 5, 6 soup kitchens. So, and this soup kitchen is specifically to the area Mr. Malema is coming from.
Correct, Your Worship.
So that is, what value must the court attach to that? Because I've read it's from donations.
Part of, yes, and through the facilitation or the involvement of the accused, Your Worship.
So it will continue.
It will continue, most likely, yes.
Okay. So there's nothing special about the soup kitchen, except that one may be very thankful that people are being served a meal. That is outstanding.
Yes, Your Worship, and it was mentioned as part of the considerations in terms of the risk of the offence.
Okay. You also said the accused has a desire to right a wrong that is driven, that he must right a wrong. Did I understand you correctly?
Your Worship, it explains where behaviour is coming from, is that if I perceive something to be wrong, naturally some people would be inclined to try and correct it, others would not.
Please, if you
depending
can.
on the personality profile of the person.
Did I summarize what you said correctly? That the accused has a desire to set a wrong right.
To see it right, wrong,
Yes.
Wrong, right, yes.
Yes. So in this case now, who gets to decide what is right and what is wrong?
So Your Worship, what I meant, and that's why I said also perceived wrong. So if the accused looks at something and he sees it as a wrong, his natural response would be to try and correct it.
Okay. So if there's an act that says you may not do it,
Yes.
then it's okay. If he decides you may because it's celebratory, then it's fine.
No, Your Worship. That is not what the intention of that is.
No, not the act. I'm going on what your evidence is saying.
In terms of explaining behaviour, so that is usually what we're driving when we take action.
Okay. Now the very last sentence you say, second last one. You were asked by counsel now specifically the fact that Mr. Malema is leader of a political party is irrelevant, and you said it is irrelevant during sentence. Did I hear you correctly?
My understanding of the question was whether it is relevant to the matter as to whether it should be a fine or not, whether it should determine the sentence, and my response was no. So my understanding is when it comes to the status of the person, that shouldn't in its own determine the sentence. It should be based on the facts of the case and the personal circumstances, and that it will consider.
Then therefore you do not see that based on that there is a responsibility and an accountability factor because of the very reason you are now saying it's relevant.
I'm not sure I understand.
Okay, let me try again, sorry. You are saying, oh, I've lost my senses here. Where did we stop?
So, Your Worship, so maybe just listening to what you were asking, if I'm understanding it correctly, when it comes to sentencing, the fact that it's a parliamentary member, the status should
Yes,
not
you said it's
influence the
irrelevant.
sentencing.
Now,
But
that's where we go. Thank you so
The fact
much.
that he is a parliamentary member also means that, as I stated in the report, that people may emulate his behavior if he has a responsibility.
That's what
to
I
be
was
more
asking.
careful,
So I couldn't reconcile it being not relevant to it being relevant.
The relevance was more linked to the status, that the status of the person shouldn't determine that, but the work relating to the parliamentary role, it comes with the responsibility and we have to act more responsibly because people can...
Last question then. You answered the question by counsel as follows. You said we need to ask ourselves, is it worth the price that we are going to pay as a community? Can you explain that statement to the court?
So you should, when we look at the stable sentences particularly, it has an impact on the family and it has an impact on the community. And when it, with the family being the cornerstone of the community, and one cannot always predict what that is. So if it impacts the community, it also impacts the structures that would, it could eventually perpetuate situations rather than to prevent it.
In essence, can you explain to me that you mean, is it worth the price we are going to pay? Is it worth it? That is what I'm asking you to explain.
So the price would be the impact on the community, having an impact on the family, having a ripple effect on the community, and also risking, and Your Worship to clarify that the sustainability of the community projects is investment in the community. And
so do you mean then that is a pardon?
It is not a pardon, it is just with the impact there, if one considered that, would that still justify a period of imprisonment or not?
Thank you. Advocate Sisa, any questions based on the court's questions?
I got distracted, sorry, Your Worship.
Sorry? Do you have questions?
No, Your Worship.
Oh.
I
Don't know.
have some questions. Madam, you asked in relation to the distinction to be made between this case and other cases, and you're taking around why this is so different from all the others. Any other instances that you referred to related to other violence that accompanied it? You said that you couldn't find any case of celebratory shooting. My question to you, arising from the Worship's question, is, in any of the other cases, did you find any instance where there was no intended target when the shooting took place?
I'm not 100% sure, Your Worship. There might have been, but there were also cases where it was, sorry, Your Worship, there were the matter that we referred to of the shooting in the case that council went through, the person did fire a discharge just a firearm, but it was now intended.
Which case is that, sorry?
The one in the South African Human Rights Commission one, that paragraph.
There was a conflict situation.
It was a conflict situation.
So there was a violent conflict situation. There were prospective or intended targets around. In this instance, was there any intended target?
There was not an intended target, no, Your Worship.
Now, you also questioned by the Worship relating to the soup kitchen, the Masakaning soup kitchen. What role does this accused play in relation to that soup kitchen?
It started off as his initiative. He, when they do struggle, he would engage to ensure that there are sponsors from the community, so he would facilitate the process and to ensure that it's run properly and the people have the means to run it.
It started as his initiative, and once it was implemented, did it play any further role?
When his help is needed with something, if there are issues with sponsors, he can intervene, but he's not actively involved in it.
Now, I'm going to ask you the question that everyone seems to be skirting around. In your view, and then compiled to what role does his status as a member of Parliament play in the sentencing proceedings? Because everybody's asked you whether it has an impact, has no impact, what role does it play?
As a member of Parliament, we would want him to be seen as acting responsible, and within the sitting, that was not the case. So because of his role as a parliamentary member, people might emulate the behaviour, and from that perspective, one needs to consider the seriousness.
But what impact does it have on the proposed sentence that ought to be imposed?
It is really part of the considerations of the seriousness as per my report.
I have no further questions.
Thank you. Thank you, Ms. Thompson. We have finalized your evidence. You are excused and you may stand.
So that is the evidence in mitigation of sentence, and I've now the evidence to read the hospital report to be accepted at the next exhibit.
Going to mark them.
Exhibits here, so I'm going to...
Sorry, before I mark them all, you're not formally submitting the article of Tutwe, not so, just the state now. It's only the report that I'm going to formally admit at this stage.
No, just for ease of reference.
That it was handed. Okay, let me hand it to you. Okay, so is it, I'm thinking since we are busy with sentence and we've had so many exhibits that we mark this one in the form of sentence. S for sentence, S1, S sentence, sentence 1. Okay. Everybody available tomorrow? I am. We're not going to get to do all of this again. Night court?
What I had in mind, the state hasn't formally closed its case, so we're still waiting to see it.
Yes.
So I'm waiting to hear from the store. should the state close its case at this stage, my proposal, Your Worship, is to
Please, I
compile,
can't hear. Please.
to compile written heads of argument by particular date, and arrange a date for hearing and for sentence on the very same day. So if there are any issues arising from the written heads that can be dealt with on that morning, and sentence can be imposed that afternoon.
Is that what parties have
No,
discussed?
I haven't discussed it about it. He thought it'd be finished earlier and to be arguing the matter today, but that didn't happen, so this is right, I've got no issue whatsoever. I'm just saying that's how it unfolded. It says asking for dates, and I don't know what Your Worship's diary looks like, all my colleagues over here. Perhaps we should come see Your Worship just to arrange a date. He's asking for a date next week, Your Worship. I don't know, I could possibly accommodate because I have a matter that's in Bloemfontein on Monday, but I don't believe it's going to run because there's a judgment handed down today that impacts on that matter, so I could accommodate something.
If you're saying next week, will that be for you to file the heads or
I don't know what you have in mind.
before?
So next week, let me explain to you.
I can file my heads, Your Worship, by next week. I'll be ready.
Yes, when will I be getting the heads?
Yes.
I don't want them on that day for the first time. Well, I can try, but
Perhaps we should take a week to do the heads and that following week. I could possibly accommodate something between the 3rd and the 6th of February. I don't know if you wish to follow that. What do you do?
I think it's just something we all need to compromise and play
I
along.
cannot do the 2nd, but I could make an arrangement for the 3rd to the 6th.
Look, I will avail myself because it's something that we must. If you want to word with your client, yes, to establish everyone's schedule. But from my side, unless I'm not present, I will try by all means to incorporate it into that day. The year's booked, but I can pre-arrange and deal with certain matters.
I have a similar situation.
Yes. Then I'll do that. All right. No, you're going to discuss dates first, and then I'll come back to court. Is that what you're saying?
Available on that day, Both of us are.
No, he wants to take instructions from the others advocates, Caesar, or obtain or hear from their availability and schedule. Is that what you? That's what you're saying.
I was rather set down for the entire term, starting from Monday, but I don't anticipate one, so that will be an advisor to me, and I can make it here.
Okay. What time do I come back? 10 minutes? State and defense? 10 minutes sufficient? Would we adjourn for the moment?
cable yam ke because the cable ifake special for le nto le, otherwise the mic yapha le cable lena ilisela kuye ikapha court yakhe
Long live the Commander-in-Chief, long live. 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 Marcha! Chio, 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 mama, chio, 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 mama, chio. Ayo shona malanga, ayo shona malanga, skotuge. Ayo shona malanga, ayo shona malanga, skotuge. Ayo shona malanga. Ayo shona malanga, ayo shona malanga, Zanja. Ayo shona malanga, skotuke lo chocho sonya mezi, lo chocho sonya mezela, lo chocho sonya mezi, Zanja. Sonya mezela, ayo shona malanga, ayo shona malanga, ayo shona malanga, ayo shona malanga, skotuke, chocho selus kokele, chocho selus kokele. Chochos de luz coquele, chochos de luz coquele, cotuque, ayo shona malaga, saca, ayo shona malaga, ayo shona malaga, tete ayo shona malaga, cotuque, lo chocho anyamese. Lo chocho anyamezele, lo chocho anyamezele, lo chocho anyamezele. Sanga, ayo shona mal, shona mala, ayo shona mala, deliver. Shona malanga, shona mala, amalanga skotuge, ayo shona malanga, ayo shona malanga, chio, chio, chio mama chio, 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 chio mama chio, ese pamido ya migo. Indo ya migo, ese pamindo ya mi, indo ya mi, ese pamindo ya migo, indo ya migo, ese pamindo ya mi, indo ya mi, ese pamodena la naso, tibuga naso. Ese pamindo yami, indo yami. Ese pam hilala naso, tivuga naso. Ese pam saga, yo sat. Ese pam hilala naso, tivuga naso. Ese pam indo yami. Sate kenge, esa tomo le polo, sate kenge, ese pamindo ya migo, ese pamon
Worship, in that regard, I can report my own friend has asked that the transcript be obtained of the evidence today to also assist us. And I also said that we should file heads of argument both sides before. So those 2 days can be just for issues to be clarified and for the finalization of this case.
Okay. I must really, the sound in this court affects me. I don't know. So
No,
if my voice is at a pitch, it's also I don't know. I can't. Are you saying you want transcripts of this witness's evidence?
My learned friend had requested it.
Oh, okay. Right. So you say that I'll note that on the charge sheet, Advocate Sisa. But
He said it was
you
necessary
do know
to be
that.
requested because we came to the High Court for the sitting. So he was afraid that wouldn't be recorded. So we made an arrangement for them to be for today to be transferred. If you wish to make an order or to a similar court, we'd appreciate it.
I hope they'll do so. They provide us with audio, no still photos while court is in session. Sorry. They provide us with audio, but maybe I will still endorse it accordingly. Okay. So you say 16, 17 April.
15 and 16 or 16 and 17, whatever suits you. Whatever I've got, 15, 16 and 17 I can sort out what is here, so it's suitable. 15 and 16, Your Worship. And then, Your Worship, when would Your Worship want the heads of argument, the written heads too? Because Your Worship said not on the last day, so I want to try and backwards from there to accommodate Your Worship.
At least if it's sufficient time to, in peace, work through your heads and that we have a conducive. Sorry?
2 weeks before you.
Yes, that's sufficient. Sufficient because.
So then we say by the end of March.
Perfect. Tonight. Okay.
I just want confirmation from one of you.
I confirm, Your Worship.
Before we have an issue on the said date, I'm again relying on you if I'm loud or if I'm too soft. To avoid the situation of today of moving venues, etc. What are we deciding on? Because then I don't want. We had a 1.5 hour delay this morning, so. And if we decide on a different venue, I will really ask it not be this venue.
Worship, I don't know the rooms here, but whatever would suit Your Worship, provided there's sufficient space. The other court, Your Worship, was extremely hot. You couldn't fit 1/3 of these people in, which was a problem.
So when will we know in advance what the situation will be regarding attendance, so that we can then make arrangements regarding the court? Okay. Then we'll.
Better to err on the side of caution than to not be prepared to waste time.
Okay. It's fine.
Your Worship, I will speak to the deputy of Bishop because she's responsible for the High Court and the dates allocated to it. So I will request to can.
Oh, we don't know whether they are in session on those dates.
Yes. So I will find out from her whether we can utilize the court on the 15th and 16th to make arrangements accordingly.
Okay, in any event, we'll do so before the time. So, for the record, I'm going to warn. Let me think. I don't know.
state closed their case on the evidence
regarding viva voce evidences. I'll hear from them now, Advocate Office. Advocate Sisa?
The state is not calling any witnesses, Your Worship. So
it will be the exchange of the written aids and arguments on that day. That is good. Thank you. All right. Mr. Malema, the matter is then postponed as if once again, if I hear correctly, and can you hear me? Because 15 April, you are on bail. For logistic purposes, I'm saying you are warned for Regional Court 4, because I can't say warned for High Court.
It's on warning, it's on warning, it's free.
Sorry.
There's summons to court.
I wonder why it's refused. Okay. Okay, that part is not before. Nonetheless, all right, you are warned, and I'm going to say Regional Court 4, so that there isn't a specific venue identified, that there's no misunderstanding. But obviously, before that date and on the date, everyone will know as to where we will convene. We will also, if need be, then continue on 16 April. Thank you.
Thank you. That's the golden
Thank you. Go to the chair.
In the judgment, the final verdict in terms of course, what will happen to Julius Malema. And we understand come the 15th of April this year is when the court will then reconvene in order to give or mete out the actual sentence against Julius Malema. So basically taking you throughout this afternoon's presentations, Malema's legal team had submitted that he is a family man with a stay-at-home wife who's currently very dependent on him and very young primary school going children, that he is a leader of a very prominent opposition political party, which is also currently in parliament, that he is also involved in various fights for justice via the ad hoc committee, which is currently probing judicial misconduct as well as other avenues, and that simply putting him in jail would not be for the interests of justice or the people. The state then counter-argued from late in the afternoon that these submissions by pointing out that the conduct of Mr. Malema throughout the trial proceedings, pointing to his misleading public utterances and those that his supporters, we understand, also share also in the public space, that this was in fact a politically motivated case to target him and not number two, which was, of course, his bodyguard. Now, his remarks against the presiding judge about her conduct, the state also further noted that Malema has shown absolutely no remorse for his actions right from day one and saw this process as almost a waste of his time among their submissions. The matter has now been postponed to the 16th of April. We understand Julius Malema remains on bail. And as you can see, there are scores of EFF supporters stationed right outside of the East London Magistrates Court. They've been intently following these proceedings from early morning for the past 2 days. And of course, what we understand now is that Julius Malema is making his way to go and address his supporters. And we will be definitely bringing you that report back to his supporters in a short while. We also do have our reporters, various reporters that are currently stationed in and outside of the East London Magistrates Court. But let's take you back a little bit in terms of how this case actually came about. I did mention back in 2018, AfriForum had launched the case against Julius Malema under the Firearms Control Act. And these were the charges that ultimately saw Malema being found guilty: the unlawful possession of a firearm, the unlawful possession of ammunition, discharging a firearm in a built-up area or public space, reckless endangerment of people or property, and failure to take reasonable precautions to avoid danger to person or property. And of course, that related to both Malema as well as his bodyguard, and also providing a firearm or ammunition to a person that is not allowed to possess it. And this was, of course, the charge that was specific to the bodyguard. Let's take you live to outside the East London Magistrates Court to listen in.
Gio, 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 mama, Gio, 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 mama, Gio, Setendea, Dea, Wemolo, 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 Setendea, Dea, Wemolo, Wemolo. Wemolo, 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 wemolo. Malema, remurataga ufela, eretamaya leyena. Wemolo, molo, zanga, 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 zanga. Julius Malema, remurataga ufela.
Well, as you can see, some very jubilant EFF supporters there holding banners saying no retreat, no surrender. Hands off our CIC. And of course, I was just making some reference to some of those public utterances that have also been sharply called into question at the court, and have also been made to reference the lack of course, amicable conduct on the part of Mr. Malema. Let me just give you some quotes from the case. EFF Secretary General Mr. Marshall Dlamini on the 29th of September last year had said they did not have a case in 2018. They still don't have a case today. The president is resolute. That is why he's been telling this woman, and that was the magistrate, of course, Toinette Olifir, to say what you want to say, because you don't have a case and you have wasted our time for the last 7 years. Now, we remember that very heated exchange that also took place in court between, of course, Mr. Malema as well as Magistrate Olifir there, where he was accusing her of ill-preparedness as well as lateness. And outside, Malema had also said the following remarks. He said, "We know from the beginning they were looking for me. They were not looking for accused number 2 in relation to his bodyguard, Mr. Snyman. They were just playing games, and today they came out openly. And as a revolutionary, going to prison or death is a badge of honor. Whatever they want to do, they must know that we will not retreat from the ideas and the 7 cardinal pillars of the EFF." Now, this is a statement which I found quite contradictory. And I raised this with, of course, our analysts there, that in light of that statement that of going to jail would be, of course, a badge of honor. Mr. Malema is now already putting it out in the public domain that immediately after his sentence, he will be appealing the ruling, even though at this stage he does not know what the official outcome will be. I guess we're going to have to wait until the 15th of April to find out. Some more of those remarks. In October, Magistrate Toinette Olivier in her judgment had said that the only aspect to be determined is whether the rifle that was in fact fired by Malema was a real firearm, and not that the court is of the view that the viral footage is not needed to enable the court to arrive at a finding in this regard. And as a side remark, it should be noted that the very same viral video footage was used by defense to indicate certain factors that they wanted to place fully on record. And in the same breath, the court was asked to rule that the viral video footage is inadmissible on the basis that the originator of the footage was not traced or called to witness. We can see Malema making his way to the podium now, of course, among some of his top leadership that is, of course, awaiting him, as well as those masses that are awaiting his address post the mitigation of sentencing proceedings. Let's listen into natural sound for a little bit.
Ayoshona malanga nkalelo chocho anyameze kalelo chocho anyamezele kalelo chocho anyamezele kalelo chocho sizomlandela ayoshona malanga ayoshona malanga ayoshona malanga ayoshona malanga skotoge shona malanga ayoshona malanga ayoshona malanga ayoshona malanga Gio 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 mama Gio Gio, Gio, Gio mama Gio, ese pa mi ndo ya mibo, ese pa mi ndo ya me, ese pa mi ndo ya mibo, ese pa mi ndo ya me. Ese pa mondela la naso, tevuga naso. Ese pa mindo ya me, hindoya, sanja. Ese pa mondela la naso, tevuga naso. Ese pa mindo ya me, hindoya me. Sate kinkle.
All right, live visuals straight outside the East London Magistrates Court. You can see the top brass of the EFF. I've spotted, of course, Mpile Mautwe. I've spotted Sinao Tambo. I've spotted Godwish Gadi, as well as the party's SG, Mr. Marshall Dlamini. Interesting song there by Sinao Tambo, Isipamu Intoyami, basically directly translating to the gun is my thing. I go to sleep with it. I eat with it. Very interesting in contrast to the fact that we are just, of course, coming off the back of those mitigation of sentence proceedings of a firearm discharged in public by the leaders of the EFF. Let's listen in.
Long live the Commander-in-Chief, Julius Malema, long live. Down with AfriForum, down. Down with AfriForum, down. Futsek, AfriForum, Futsek. Futsek, AfriForum, Futsek. Futsek, AfriForum, Futsek. Niabe Sabana. Niabe Sabana. Viva EFF, viva! Thank you very much, fighters. Let me take this opportunity and greet the Commander-in-Chief, the officials of the EFF, the Central Command Team, the provincial leadership that is amongst us, the sub-regional command teams, and most importantly, the ground forces of the economic freedom fighters. Dithi kuni halala Mpumalanga halala. Halala Limpopo halala. Halala Gauteng halala. Halala Northwest halala. Halala Northern Cape halala. Halala Free State halala. Halala KZN halala. Halala Western Cape halala. Dibize uchairperson of the Eastern Cape to come and welcome everyone and say halala Eastern Cape halala.
Sufike khaya ubatshele hayila phuma khona he mahlathini aselusaka ofike khaya ubatshele lasibuya khona he mahlathini haye aselosaka haye kawuthathe nansi ekheye haye shaya ututula lonke lesentsha haye zala mapolo haye kawuthathe nansi ekheye tubulubulala sonke lesentsha haye zala mapolo ngobutshutshu yinkokeli yethu bambi isandla sam Malema Chuchu Malema bambi isandla sam wechuchuba uchumana yingmameli yethu wana commander Julius Malema bambi isandla sam wechuchuba usibambu ngasiyekele Julius Malema hayichuchu Malema bambi isandla sam Amanda how two FIFA the commander-in-chief FIFA the commander-in-chief FIFA EFF FIFA. Thank you very much, National Chair. We want to greet the commander-in-chief, the leader of this revolution, who is seated here. Like we said last time that the commander-in-chief will come out of that door and meet the ground forces here. We greet the commander-in-chief. I won't belong SG, TP, National Chair, TSG, TG, the CCT members, and all the provincial chairpersons and secretaries, but most importantly, the ground forces of the EFF, we want to welcome you, our prepondering. From yesterday, you have demonstrated that our commander-in-chief is not alone. He is not the person that is trialed there. We are also being tired. The revolution is being tired because anything that seeks to silence him, that thing wants to silence the revolution. President, the chairperson of Limpopo told me that the ground forces of Limpopo started leaving Limpopo on Wednesday. And they are still here. They said they will wait for you. The Mpumalanga ground forces, they are here. The Gauteng ground forces, they are here. They didn't sleep. We are here to receive you, President. We are here as this family to receive yourself, and we were happy to see your family, to show us that you are not only loved by us, because some of us who claim to love you, they turn their back on you. Like there's some people that we know, we won't mention name, that turn their back on you. They thought that was the end of you. But people of EFF came upon doing the deep rural area where there is no hope. But they said, our president, we will follow him. Uchuchu wetu sizohamba naye. That is the message that is being sent here. President, we won't belong. Naba bantu bako. You always say when you are closing your speech, bonge labantu abakiti. And we are here to receive you, our president. National chair, we won't belong. We welcome the president. We are receiving him. We welcome all the political parties that are here. We welcome the family. We salute the chairpersons and secretaries who make sure that there is no incident coming. They have committed that there won't be incident going back home. We salute the ground forces as Pata throughout these 48 hours. Amanda! Ubuilu chuchu buile! Thank you very much, National Chair.
Thank you, Chair. Futsek, Afri Forum, Futsek. Futsek, Afri Forum, Futsek. Thank you very much, fighters. We are going to be moving very quickly because most of you have to travel long distances. President, we did not sleep last night, but the spirit that is here does not indicate that we did not sleep. Give yourselves a round of applause, fighters. Amongst us, fighters, we have the family of the president. I would like them to stand up and just wave to the ground forces of the EFF. Does anyone want to come and greet? Does anyone want to come and greet the crowds? Okay, that's fine. And then we have political parties that have joined us here today. I'm going to call upon Yongama Zigebe, the Secretary General of UDM, just to come and wave and say hi.
Amandla! Amandla! Viva EFF, viva! Viva EFF, viva! Booyah, Julius Malema, booyah! The revolutionary spirit of Julius Malema is alive! Viva EFF, viva! Thank you very much.
Thank you very much. Chapelo Ahmad, Chairman of Al Jamal. Come forward, please.
Viva EFF, viva! Long live the spirit of Julius Malema, long live! Long live the spirit of Julius Malema, long live! Rena le wena auwe muso wa magodu auwe. Auwe, mmuso wa maburu, auwe. Thank you, comrades.
The next one is the president of Zambia, EFF Zambia. EFF Zambia.
Viva EFF, viva! Viva EFF, viva! Long live the CIC, Julius Malema, long live. From Cape to Cairo, the revolution has come. We are thankful that from here, the fire to liberate the people of Africa has come. Thank you so much on behalf of them.
Thank you very much, EFF Zambia. Then we have EFF Lesotho.
Amanda! Amanda! Hi hole, EFF, hi hole! Hi hole, EFF, hi hole! How muso abalotsana, how muso abalotsana, how long live the spirit of CIC Malema, long live! Kaleboa.
Thank you. EFF Namibia.
Viva EFF, viva! Viva EFF, viva! Amandra! Amandra! Down, recht Afrikaan, down! Down, hij is slecht Afrikaner, down! Viva CIC, viva! I thank you.
Pudemo. The next one is Pudemo. President Mlungisi of Pudemo.
Amandla! Amandla! Viva EFF, viva! Viva EFF, viva! Long live President Silo Julius Malema, long live! Down with white supremacy, down! Down with white supremacy, down! Forward with the spirit of non-surrender, forward! Forward with the spirit of non-surrender, forward! Ayule EFF, ayule! Spilele, President Malema, spilele! Amandla!
Thank you very much, Pudemo, Swaziland, the president of Pudemo, Swaziland. Thank you very much. And now I'm going to call upon the former president of the Student Command, the youth leader, Sihle Lonzi.
Amandla! Kaweto! Osinyova, Sonyova! Osinyova, Lokavame! Osinyova, Sonyova! Osinyova, Loholume! Osinyova, Sonyova! Osinyova, Loholume! Osimnyova, Somnyova, Osimnyova, Nidiva, Fachaza, Nidiva, Sosha, Osimnyova, Sonyova, Osimnyova, Lohulume, Osimnyova, Somnyova, Osimnyova, Lohulume, Amandla! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live! Hands off the Commander-in-Chief, hands off! FUTEC AfriForum, FUTEC! FUTEC AfriForum, FUTEC! FUTEC Donald Trump, FUTEC! FUTEC Donald Trump, FUTEC! Long live the EFF! Long live the EFF Youth Command, long live. Thank you very much, National Chair. Asinamazwi mate namhlanje. We are just here to say kuwe Mongameli. Xa bebabamba wena babamba thina. Xa bethinta wena bathinta thina. We know that this war against the Commander-in-Chief did not start today. Even when the president was leading young people in the Youth League, they were taking him to court every day and every year. President, even when you were young, you defeated them. So why do they think they can touch you now when you are stronger, when you have more experience, when you have so many fighters in South Africa who are willing to put their bodies on the line, when you have so many students who will bring this country into a standstill? They will never, because they failed to defeat you when you were a young person. President, we know where the instruction to arrest you came from. When Ramaphosa took white people to the White House, not John Steinhazy, nor Rupert, Donald Trump asked Ramaphosa a simple question: why are you not arresting this man? So Ramaphosa came back to South Africa together with AfriForum, sent by Donald Trump, thinking that they can arrest you, President. Donald Trump must know this is not in Venezuela. He will never bully the EFF. He will never bully fighters of the EFF. He will never bully the youth of South Africa. Amanda! Hey, two!
Thank you very much. And now we are going to call upon all the chairpersons and secretaries of provinces just to come forward and greet the masses. Please come forward.
Amanda! Long live the Commander-in-Chief, long live! Down with AfriForum, down! Amanda!
Futek Donald Trump, Futek! Futek Donald Trump, Futek! Mai Buye! Amanda! Molweni Monty, Molweni!
While as we await the CIC, the chief in command there, Julius Malema, to take to the podium. These, of course, are just, I suppose, side messages of support. As we understand, there's quite a number of entities as well as other political parties, as we're hearing Al-Jamaa, as well as the UDM, as well as the EFF from other parts of the continent that have all convened to show support to the CIC. I'm sure you've just heard, of course, Sihle Lonzi there saying this case was actually cooked up in the Oval Office when Cyril Ramaphosa had taken that delegation. And in fact, I do remember when Donald Trump had shown those images and had asked specifically President Cyril Ramaphosa why was Mr. Julius Malema not arrested. So I suppose Sihle Lonzi going back to that label and saying this case was basically as a result of that visit by the South African delegation to the White House. We are currently bringing you these live visuals from right outside the East London Magistrates Court. That is, of course, after the mitigation of sentencing procedures in the Julius Malema case. He should be taking to the podium right now. And of course, we are expecting some serious reactions. I'm sure you've also seen going into this mitigation of sentencing proceedings. There's been a lot of comparisons already being drawn to the unrest that followed former President Jacob Zuma's imprisonment in 2021. I think Sihle Lonzi has just also made similar utterances, although not in that context, saying that they will not take this matter lying down. And if they so do take on Malema, that is the justice system, that means that will be an attack on all of them. And he says they cannot eradicate all of them as the supporters of the EFF. Well, this is what analysts actually think. of course, about this. In fact, I'm not going to, all right, we're going to continue there. I was hoping to have an analyst with us on the line, but I'm going to continue on that trajectory where I was talking about the comparisons already being drawn to whether there could be possible unrest in, of course, the event that Julius Malema is in fact sentenced to prison, like we saw back in 2021 after former President Jacob Zuma's imprisonment. Analysts seem to think that, of course, the political consequences may not lawfully influence the sentencing, and the court cannot then concern itself with what the implications of a judgment might be, especially if those implications themselves actually constitute unlawful conduct, and that, of course, in order to maintain public order, the responsibility, it is the responsibility of law enforcement and not the judiciary. So we are awaiting the CIC there. You can see him there as, of course, he is about to address the masses in terms of what is the way forward. But I suppose we've all heard the way forward. The CIC has been very public in his statements that, of course, the minute the judgment comes in, himself and his legal team, they will then take that sentence for appeal. So the questions now arise. What then happens if he does go to jail in terms of his political career? What happens at the helm of the EFF? And most importantly, what happens in Parliament? Well, I'm hoping to get some more analysis as well as legal advice in terms of what would the possible, of course, proceedings after that actually entail. You're currently watching SA Today. We're live here on the SABC News channel, and we've been bringing you, of course, the mitigation of sentence proceedings in the matter of the firearm discharge of President of the EFF. That is, of course, Julius Malema. And of course, we're going to try and listen in. But we do also want to apologize as we've been bringing you these live proceedings. There has been quite, how do I term it? There has been some foul language, and we do apologize as we are bringing you these proceedings live from, of course, from the East London Magistrates Court, from the various supporters there. So we'd like to, of course, disassociate ourselves, in fact, distance ourselves as the SABC from that type of language. And of course, we will be bringing you Julius Malema as soon as he is ready to come and talk to the supporters of the EFF, of whom we understand a lot of them have traveled far and great. Others, we understand, have come from Guyana, from Limpopo, to come and be part of this large crowd that you're seeing in your insert screen there, that has been, of course, in support of their president for the past 2 days. Now, this was the mitigation of sentence that started in earnest on Thursday. It was supposed to be sentencing procedures, and a lot of you were actually expecting that on Thursday we're going to get the sentence. But no, in this regard, the legal process is that submissions and representations still have to be made in terms of what the initial, in fact, the final outcome of what the court will decide in terms of the right sentence that they will mete out against Julius Malema, who has been found guilty of those 5 charges for, discharging a firearm in public in terms, of course, of Section 13 of the Act. All right, we're still monitoring those live proceedings here on SA Today. We will be bringing you, of course, that speech by Julius Malema. And of course, we are just watching what we are waiting to hear what he is going to say. Leanne Mathis currently taking to the podium, and I suppose that signals the time that the CIC is about to take to the stage. And of course, Julius Malema, for 2 days sitting there in the dock and awaiting his fate. That is the SG Marshal Dlamini there, also, I suppose, taking to the podium. Quite a lot of the senior leadership of the EFF has actually come to East London in support of the CIC in this matter. And from day one, you know their sentiments, and even now, they still believe this is a political witch hunt. It is a matter that is solely designed to take care of Julius Malema. And I suppose this question becomes quite interesting if they're saying this was designed to take care of Julius Malema's political career. Because if you think of it, we're going to the local government elections. So one wonders then, why what would a decision to actually jail Mr. Malema ahead of the local government elections and the implications thereof would entail. All right, we're going to bring in political analyst Dr. Levi Ndo to also just help us understand this matter. Dr. Ndo, it's good to have you with us. Thank you so much for your time. So according to you, I mean, let's talk about the possibility of Julius Malema being taken to jail. What are the implications of that decision politically there, so, sir? Good afternoon.
1, 2, 3.
And that was on behalf of all the Central Command team. Thank you, Commissars.
Go ahead. So,
Wave.
I was saying, how does the possibility of Julius Malema actually being sent to serve some jail time affect the overall South African political arena, just starting from his home base?
And then our former officials were also here today. I know that the first and our second DSG, but they are somewhere and I can't see them. I will call up our second national chairperson, our whip in parliament, and also the convener here in the Eastern Cape, Commissar Veronica Mente. Please come and greet us.
And what appears to be the fear by most people is that the vibrancy, the kind of leadership.
Mandla! Amandla! Sipilele, Commander-in-Chief Silo, Julius Malema, Sipilele! Sipilele, Commander-in-Chief Silo, Julius Malema, Sipilele! Awafa bathakathi mabafe! Mabafa bathakathi be-AfriForum mabafe! Hands off our president, hands off! Hands off our president, hands off! Fuck Donald Trump, fuck off! Fuck off Donald Trump, fuck off! Fuck off Ramaphosa, fuck off! Fuck off AfriForum, fuck off!
Other political parties, Julius Malema would always be in the forefront of doing so. But at a time of confrontation, at a time of accountability, when it is required, would also be in the
So why are you looking at me? Coming greet one more time. I'm introducing you officially. Nontando Nonglungchungu.
Amanda! Viva! EFF, viva!
What is right.
Thank you, National Chair. And then our Treasurer General, Commissar Ompile Maiotwe.
Speaking about the
Down AfriForum, down! Down Donald Trump, down! Down Cyril Ramaphosa, down! Down with the ANC, down! Forward to economic freedom in our lifetime, forward! Kina President Julius Malema, Kina! Kina Julius Malema, Kina!
The judge says that...
Thank you, TG, the Secretary General of the Economic Freedom Fighters, who made sure we are here today. Commissar Marshall Dlamini.
Amanda! Amanda! I saw me fight, I saw me! I saw me fight, I saw me! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live! Long live the Commander-in-Chief, long live! Manda!
Thank you, SG, and our Deputy President, Commissar Gottfried Gardi.
Amanda! Amanda! Was our 2026 local government elections? Was our 2026 local government election? Was Sipilele, Commander-in-Chief, Sipilele! Sipilele, Commander-in-Chief, Sipilele! Haikule, EFF, Haikule! Haikule, EFF, Haikule! Thank you very much, Ground Forces, public representatives of the EFF, members and supporters of the EFF, our guests from all other political parties with us here, the staff members of the EFF, and the fourth estate. I see all of them are here.
But what we need to acknowledge is that
my task is the most difficult task.
Your opponent
Every time
always be checking
we are
on
told
what
it
you
is the
do
most
and what you do. And
simplest
anything that
task.
they can take
It
you
is
on
not very simple
so that you are able
because
to fall
AfriForum
and organize your party
is forever
to do so.
convening
And that is
rallies for the EFF
AfriForum
in the
is
Eastern Cape.
in this case.
We are here because of the EFF. We must ensure that EFF goes to
intentions.
Parliament, set up, draft and submit a bill that will make sure that AfriForum is prohibited and is a prohibited organization in South Africa. Without much ado, President, the masses, the ground forces, South Africa and Africa, Africa in diaspora, including the White House, has been waiting for this moment to hear the message from the Commander-in-Chief, Julius Malema. Comrade President.
Amandla! Amandla! Viva EFF, viva! Data, EFF, data! Data, EFF, data! Amandla! Thank you very much, Raleboa. The program director, our national chairperson, the treasurer general, the DSG, the SG, and the deputy president. We thank all the chairpersons and secretaries of provinces who are here today, members of the central command team, and leaders of provinces who are with us here, and the sub-regional leadership that is here today, and the ground forces of the revolutionary movement of the economic emancipation in our lifetime. Re lebohe ka moka batswadi ba rena ba Malema ba ba beng gona mo. Re lebohe le bashabi ka moka ba ba tloleng kgola le kgauswi ba re ba tlo re supporta, including Ntate Maja le mokhumahadi wa gagwe, and everybody who's here today to come and support us. We appreciate all of you, and we don't take for granted your support, because you could have done other important things other than coming here, but you thought it was important for you to come and put your bodies on the line in defense of the revolution, in defense of the economic emancipation, in defense of the only organization of the petrol attendants, of the domestic workers, of the construction workers, of the farm workers, of the downtrodden, of the teachers, the nurses, everyone who is dejected by the system that benefits the minority. This organization belongs to everyone who doesn't own the means of production. We salute our international visitors who are here today, who are confirming that the idea for economic emancipation is not only in South Africa, it's in the whole of Africa and the diaspora. We thank all political parties for putting their differences aside to come and defend the Constitution of the Republic of South Africa. To acknowledge our MKP is also here to support the revolution. Comrades, we are saying to you, your discipline is something else. Some of you traveled for 2 days. Those who come from Limpopo, when they go back, they are going to arrive on Sunday. But we must thank the TG, our organizer, TG, and all leaders who made a contribution to make sure that you travel safe. We want to bus drivers, if you feel tired, park on the side and sleep. You must not insist on driving a bus because you are going to kill the future of South Africa. One EFF member who dies, you must know 100 people lose hope because that fighter passed away. So do not destroy the hopes of the masses of our people. We send our condolences to those children who died in Gauteng in an accident that could have been avoided. We say to the taxi drivers, we need to change our behavior because you are carrying the future of South Africa. Our children cannot be transported like you are transporting potatoes, like you are transporting cabbages. You must know in that taxi there is one head which is going to change the life of that particular family. And when you kill those children, you are killing the future of South Africa and the hopes of that family. Fighters, we must never get discouraged. It doesn't matter what the magistrate decide. The revolution continues. We know why we are being attacked. We are attacked because we are the only black authority. We are the only black people who speak and other people listen. They do not listen to anyone except the EFF, even when they pretend not to love the EFF. But when the EFF speaks, every black person wants to hear. What did the EFF say on this matter? That's what white people are scared of. They are scared of a black authority. We are the black authority, and we speak for black people with authority, and we don't doubt ourselves when we speak for the voiceless people who are oppressed by white supremacy in South Africa. The white people who brought us to this court, it is because they don't like being challenged. When you challenge them, they want to use you as an example. I've been an example for the rest of my life, and I will be an example even in my grave. I will never retreat. I will never surrender to white supremacy. No prison can make me to retreat from my ideas. No death will threaten me to retreat from my ideas. Nobody will ever intimidate me and change me for who I am, because I am black and I'm proud to be black, because I'm a voice of the black people and I'm proud to be the voice of black people. Kill me now if you want to kill me. Kill me, coward. You are scared of a political debate. You use court to settle the political differences. I am not scared of prison, neither am I scared of death. When I joined the struggle, I knew three things might happen to me. They will either arrest me or they will either kill me. If they don't kill me, I will attain my freedom. We fight for the freedom. We are not scared of death. We are not scared of prison. We are scared of poverty. We are scared of unemployment. We are scared of being landless. We are scared of living without our dignity as black people. Comrades, you must be strong as leaders of the revolution. For because they will never love the revolution. They went to take Maduro from Venezuela without any due process, without the respect of the international law. If they can arrest a president of a country without following the law of the world, who are we? We are ready for them. We must never ever be shaken by a court that is informed by hatred, that is informed by politics of AfriForum. AfriForum is nothing. They must pray that the EFF must never be a government in South Africa, because the day the EFF becomes a government
in South Africa, we are going to lock up all AfriForum members because they are terrorists, because they are anti-South Africa. They undermine our country and its freedom and its constitution. That's why they established Orania. When the constitution says we must come together, they continue to want to stay alone in isolation of black people. We are not the ANC. We are not scared of AfriForum. Fighters, the law of this country will prevail against racism. No racism can prevail over the law. Any ruling that is unjust, any ruling that doesn't follow the law and the Constitution doesn't deserve our respect. We must never respect anyone who uses the Constitution of the Republic of South Africa to perpetuate racism, to perpetuate white supremacy. Let's make sure that as fighters we educate our people. What the Boers did, they took out the brains and left us with empty heads. We must refill the heads of our people with ideas that are going to liberate them. The day we said we want the land of our people to be returned to our people without compensation, that is the day we committed crime in South Africa. That's why they hate us. They want to continue to be in charge of the stolen land. This is our land. No sheep came with a land when they came from Europe. They found this land here. And we are right when we say this is our land. We'll expropriate it without compensation, whether they like it or not. We will nationalize the mines. We will establish the state bank. We'll make sure that the people of South Africa participate in the economy of South Africa without any hesitation. Comrades, let us make sure we bring the economy of South Africa to look like Parliament of South Africa. By how Parliament looks, you can see who are the majority. Majority are black Africans, a minority are whites. That's how the economy should be. The majority of the economy must be owned by majority of South Africans, and majority of South Africans are black Africans. So we will fight this fight until we win. If we don't win this fight, we would have laid a firm foundation for future generation to come and take the spear and continue the battle for economic freedom in our lifetime. No child is going to follow cowards. When you're scared of prison, no child will join the struggle for economic freedom, because they know that those who came before them, they were scared and did not do anything. Comrades, let us be in the forefront of restoring the dignity of black people, so that when we die, our children come to our graves to come and salute, but go to the grave of Ramaphosa and pee on that grave and say, here lies a sellout which did not return the land of our people into the hands of the rightful owners. You must die a revolutionary. And being a revolutionary doesn't mean giving people RDP houses. There is nothing revolutionary about RDP. There is nothing revolutionary about patching a pothole. There is nothing revolutionary about creating jobs. Revolution means a complete overhaul of the system and introduce a new system that is going to benefit the majority of our people. Who are this majority? The working class of South Africa must be the one that benefits when the revolution wins at the end of the day. The revolution means we must replace white supremacy with the dignity of black people restored.
in South Africa, Africa, and the world. Donald Trump, whether he likes it or not, his term is coming to an end, and he's going to go to jail unless he does the quickest thing and drink poison. The world will never forgive Donald Trump for what he did by destabilizing the whole world and undermine the international law. His day is coming, and we must not be worried about a man who speaks about politics, yet he knows nothing about politics. How do you say, I don't follow international law, I follow my emotions, how I feel? What kind of politics are those? He's simply telling you his empty head. The only thing that makes people respect him is because he's white. But otherwise, ya Donald Trump, is a stupid. When you see him, every time when he appears on TV, you must say, Nangu Satan, so that all our children know that Donald Trump is a devil that wants to destabilize the world peace, and we are for peace, we are for unity, we are for the freedom of all people of the world. We don't fight white people, we fight white supremacy. And the illiterates will not know the difference. It's up to you, the ground forces, to go door to door explaining to them that we don't hate white people. We are one thing. How can we be internationalists in outlook yet don't want white people? Internationalism is constituted by all different kinds of people, including white people. How can a Marxist organization hate white people and love Karl Marx? Because Karl Marx was white, Lenin was white. So why do you subscribe to the philosophy of the people who are white and they say you hate white people? It's not true. There is no white genocide in South Africa. There is black and white love in South Africa. Every white person who loves a fellow black brother is our brother. We will do everything in our power to defend those white people who love South Africa and who love our own people. But if you come with a tendency of AfriForum, we'll make sure that you don't enjoy the peace we enjoy. Fighters, I want to thank all of you for your discipline. I want to thank your leaders for your discipline. When you leave here, you repeat exactly what you did when you were coming here. We are coming back on the 15th and 16th of April because today we were having our own witness she took the whole day. And by the way, it was a white woman, an Afrikaner, who was invited by the EFF to come and talk about how beautiful is Julius Malema. So when you say we hate white people, Julius Malema was being described by a white Afrikaner woman in court. Ario is so sweet. Hey. But what's the problem? He's a bull. He says, it's not a bull. If he doesn't agree, he comes across as being very pushy, and you can misunderstand him. But otherwise, he's very good. Ke fa batho ba o sokola ba 700 every day ka 3 o'clock ke ba fa dijo is more than a year now. This racist are, so why do you tell me about that? How does that have to do with anything? Because atse bi tsokolo o legendary ya utsiwa le papara mo fa di khomu tsa utsiwa tsa utswetswa black people. That's why we'll never understand the importance of the soup kitchen. That's what racism does. Racism, when it shows its ugly face, it never knocks a door and say, hello, I'm here, I am racist. You must listen to the connotation of the utterances of a white person to know if this white person is racist or not. Once you say, what is soup kitchen? What does that have to do with anything? You can hear that she's offended that 700 people, black people, are eating every day. If it was according to her, those 700 people should be eating from the dustbins of white people, and the EFF said, hell no, they will not eat from the dustbins of white people. So let's go, comrades, and look after our communities and look after our families. You will never take care of a community if you can't take care of your family. You must look after your family. And looking after your family does not mean you must have money. Just show them love. Give them a hug and remind them how many times, many times a day, how much you love them. That gives them courage. That keeps them inspired. They know that even if the world out there hates me, my mother, my father loves me for who I am. Once you love your family, you love the community. Once you love the community, you will love the society of South Africa. Once you love South Africa, you will know that what they are doing in Palestine is not in line with your family values, and therefore you will stand with the people of Palestine. It starts at home. All of us, when you call yourself a fighter, look after your family. Make sure they know your love and appreciate your love. You know, the most important thing is to have your family behind you. When I'm seated there in court, my wife sent me a message and she says, you look so lonely alone in the court, in that box of the court. I said, it can look like that, but if you look behind me, all my aunts are behind me. They built a shield. All my relatives are behind me. They are a wall that says we are going to fall with this child. They will never do that if I did not give them love. They are today here to return the love I gave to them. They are here to return the investment I invested in them. Invest in your families, they will invest back at you. My family is the EFF. You are all my family. The leadership of the EFF is my family. All of you, you know that in the EFF we love each other and we support each other and we don't conspire against each other as we go into local government elections. We are not going to fight. We are not going to cause divisions. We are going to look amongst ourselves and say the best amongst us is this one. It doesn't mean you are not the best. We are choosing one of the best amongst the best, and we are putting that name forward. Do not bring drunkards. Do not bring women beaters. Do not bring criminals to be candidates of the EFF. Bring the ground forces of the EFF who are helping the elderly in the communities. Eastern Cape, this is your opportunity to remove the corrupt ANC. Limpopo, remove the corrupt ANC. You were taken by floods because they did not build roads for you. Here in Eastern Cape, it's very painful. What's happening to this province? It requires the citizens of Eastern Cape to rise and defeat the ANC and bring in a progressive government that is going to look after them. Fighters, we live here, we go to the ground. We are not going to play. Shame. It was a nice outing. Livile le bone le beach. Les kabalara ser le finyo ye. Le filenyo ye. Negabocha SG Tsamo cheka bala balimpopo ka gore abatse bo sima bo khama. Ke metsi ka kwa beaching. Bara balimpopo ke bona first ones. Dinoru utswa ka basi jar le watle le kae. Le rwale metsi ka dikupu ape le ska la thasaeta le wate. Ele kwa le fela le chela mo maotong. Ka re ba ta o topa maoto batho. So you are going back and then you are going to work. It's time for door to door. Next weekend, we are going to our first strategic planning meeting. From there, one by one, every day, everybody must be on the ground working for the victory of the EFF. Do not be scared of what is happening. The idea is to kill the EFF. You must build the EFF. If you want to defeat this magistrate, build a strong EFF in the village where you come from. You want to defeat racism, build EFF, street by street, house by house, school by school, college by college, university by university, factory by factory. The EFF must be everywhere. The EFF must be in each and every family in South Africa. There should not be a family without a supporter or a member of the EFF. That is your duty. It's not Julius Malema's duty alone. In your village, you are Julius Malema. Take charge, commanders. Do not take advantage that others can write and you can write and speak English and think you are better. Our people don't want English. They want a person who will listen to their grievances and solve their grievances. Even if you don't know how to write, ANC says they want metric, but they've got some leaders there who don't have metric. Community workers are some people who can't even write or read, but they can hear, they can speak, take the grievances straight to the municipality, come back with a grader and open the roads over the weekends for the funerals of our people. What does that have to do with anything? So, if you know Saberegeli community, if you are not working for community and hoping to come to be a councillor of the EFF through a back door, I just gave you tips. Start tomorrow to work for the community. Then you'll be a candidate of the EFF who knows what a community is about. So I'm very happy, fighters, to see all of you, and I always say that I'm very happy when I'm amongst fighters, because I know this is my safe space. This is where my protection comes from. We want to thank our traditional leaders who wished us very well. We want to thank our pastors who are praying every day, praying for us to emerge victorious. We say to them, keep those prayers coming, not only for Malema, but for the victory of the EFF when we go for local government election next year. Buffalo City must belong to the EFF. Fighters, it is very clear that those who don't want progress amongst black people, they target the EFF. So let's go and protect the only weapon black people have, and that weapon is called the EFF. We thank all the journalists, Shem. Even like Sakina, I haven't seen Sakina in a long time. Morning Live. They don't invite me to Morning Live. She's here. Maybe I'll appear on Morning Live. We thank all of you. I saw one black African journalist. I don't see him now. On social media. In a plane, he said, EFF people are singing in a plane as if Malema won. Then I went to him inside court. I said, what did you want them to do? You wanted them to cry. And they proved you wrong. Because that's what you want them to do. You always want to see them cry. You never want to see black people happy. And I said, stop your self-hate. I asked him a question. When a person dies in your family, what happens? We are sad, but we sing. When you graduate with your diploma degree, the same songs we sang in a funeral, we are going to sing them at your graduation. Santa Marina. Raopela. And the Lopele let amamo. Le bakwesha botlhoko. Le pelo tsa bona di ababa. Kareban. Why are you offended by black people singing? In happiness we sing. In sadness we sing. We love singing because that's how we comfort ourselves. But if you listen to those songs properly, they are actually not songs. Those are war cries. Those carry a message. We are trying to educate through song that people come to understand what the revolution represents. I thought I must not be confrontational with him. He's still very young. So I was teaching him to love himself. Because if he loves himself, he will love a black person who's singing next to him. Even if you don't know the song, as long as a black sister is happy singing, you just join humming. You are joining your own. So please, as you go back, sing back, go home safely, be disciplined. In the plains, there is discipline. If you sing, they say stop singing, you stop. Because those things have got so many rules and it's not basis of the EFF. Marabala clear side, we sing. So, please, don't sing, don't fight with them. Because they want to project us as if we are fools, as if we are baboons that can't think. We can think, we've got brains. We are consoling ourselves in song. We hide our pain behind song. We don't sing because we've got no brains. We sing because we want to communicate our deep-seated feelings and how we view the world today. So please, in song, in unison, together as one, you are going to return to your home safe. No one is going to harass a female. Please. Monges, don't touch. When you go to KZN, don't touch nothing. Straight, Hambakaya. All of you, no female must be harassed. When you are in a bus, you see a female showing signs of being uncomfortable. You must make sure that indeed there is nothing happening to her. Otherwise, you would have failed our females. We are going to make sure they arrive home, all of them safe. Because if women can feel safe in the EFF, more people are going to come, especially men. Because men go where women are. So we must bring more women in the EFF so that these men can come to the EFF. But if you harass women,
in the EFF, they will leave. And you men will remain alone in the EFF, and it will never govern South Africa. How do you govern without a majority? Women are the majority in South Africa, whether you love it or not. Please don't, this thing of not paying maintenance, support for children, is also an abuse on women, because they are the ones who struggle alone with your children. Please don't be a fighter and don't pay maintenance. Fighters pay maintenance and support their children, because if you don't support that child, it means you are not supporting an African child, yet you claim to fight for an African child. You are a fraudster. Start with your child before you can talk about our children. Support your children, support each other. Let's go back to KZN, let's go back to Western Cape, let's go back to Northern Cape, let's go back to Eastern Cape, let's go back to Northwest, let's go back to Free State, let's go back to Mpumalanga, let's go back to Gauteng, let's go back to Limpopo. And when we arrive home, we must tell them victory is certain. We shall overcome. Amandla! Amandla! Viva! EFF, viva! Auno magubi! Siaya! Siaya! No magubi! Siaya! Siaya! No mabese tubola! Besi shaya! Besi bopa! No mabese tubola! Besi shaya! Besi bopa! No magubi! Siaya! Siaya! No magubi! Siaya! Siaya! No mavese tubola! Besi shaya! Besi bopa! No mavese tubola! Besi shaya! Besi bopa! Who left? Who right? You must saw! Who left? Kita! Killer man! Siltatile, ilagit. Siltatile, ilagit. Zibrankoto, alliance. Zibrankoto, alliance. Shoot to kill, killer man. Shoot to kill, Yamasa. Brr, pa, pa. Brr, pa, pa. Kill the poor, the farmer. Kill the poor, the farmer. I repeat, kill the poor, the farmer. Kill the poor, the farmer. Attention.
Amanda! Amanda! Viva EFF, viva! Thank you very much, President. Thank you very much, fighters.
as the President has said, let us all be disciplined, let us be safe on the road, leadership of provinces, until each and every fighter has reached home. Our job is not done. Same to you, leaders of sub-regions, until each and every fighter has been accounted for, nothing has been done. Let's make sure we do that. We want to thank the DOR, we want to thank the volunteers, we want to thank the brother who helped us with this stage president. There is a brother who's with us who said it doesn't matter how late, they're going to work overnight with these workers to make sure that the EFF is safe in the Eastern Cape. We want to thank everyone who was here to support the revolution. Sifuna ukuthi nihambe kahle fighters, nihambe kahle nibe phephe emakhaya. Amandla! Amandla!
Hello? Melissa, Lumko's trying to talk to you. You can rap now. Let's just wrap it. Just wrap.
Malema. Ifata, Danya Mesela. Ifata, Danya Mesela. Ifata, Danya Mesela. Ifata, Danya Mesela. Namagutungu, Namagutima. Ifata, Danya Mesela. Namagutungu, Namagutima. Ifata, Danya Mesela. Ifata, Danya Mesela. Ifata, Danya Hayaya. Ifata, Danya Mesela. Hayata, Danya Mes. Hayena Maguntima. Namagutungu. Ifata, Asamba. Hayena Maguntima. Namagutungu. Ifata, Hanyam. Hayaya. Ifata, Hanya Mesela. Ifata, Hanya. Aminiswa. Ifata, Hanya Mesela. Ifata, Hanya. Hanya. Ifata, Hanya Mesela. Ifata, Hanya Mesela. Ifata, Hanya Mesela. Ifata, Hanya Mesela.
She says she's dialing. She says she's dialing. She's not dialing.
Samba, Hayena. Ifata, Hanya. Hayaya. Ifata, Hanya Mesela. Ifata.
Hello?
Hanya Mesela. Amanda.
Okay. All
Go
right.
on, King Tetrayo. Go on.
All right.
Go on, Kamaralingana. Go on. Be safe, fighters. Let's go.
Hello? 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 Okay.
Very hopeful that sometime he will be then appearing on Morning Live. Good afternoon.
That took me by, I must say, that took me by surprise. I was here minding my own business. I didn't know that we didn't invite the CIC to Morning Live, but hey, I guess he invited himself, so we'll wait to see when that happens. But I must say, what a day it has been. It's been an exhausting day for the thousands of EFF supporters who've showed up. They've sat here in the sun throughout, waiting, listening and watching, following the proceedings on these big screens. But of course, it wasn't to be. So we returned back here on the 15th and 16th of April because there's still some documents that need to be perused. And I guess Magistrate Twanette Olafir has to make up her mind as well. But of course, you heard there from all the EFF leadership what they had to say. And I must say it was very interesting watching the reaction from the crowd. But more so, it is going to be what this elicits going forward. And we will be here, right here, to make sure that we bring all of those reactions. I must also just say that the charges, of course, still stand because Julius Malema has been convicted. The EFF and Malema have indicated they will be appealing, so we await all of that. They seem to have made peace with the fact that Julius Malema, of course, will be found guilty. He has been found guilty already, I should say, that he will be sentenced by this particular court. And it seems, if you listen to the judge and if you listen to Advocate Noel Caesar, who was, of course, the state prosecutor, that they are, at least the prosecution is pushing for the maximum, the minimum sentence at the very least, which is 15 years. But of course, we heard from the witness, who is a social worker in private practice, and she was speaking about Malema, his character, and basically saying that the things that he was saying, he's perhaps not such a bad guy, perhaps misunderstood. But that being said, as we say, the conviction stands. Will Malema and his supporters, when the time comes, ultimately accept what the law says? As he said, they are constitutionalists, but all, of course, will play out before us, because from this court, it definitely will go to the High Court, because they've already indicated that they will appeal. And if they have to take it all the way to the Apex Court, I tell you what, it's been a deafening day, and some people still remaining behind. But of course, it's been one for us here on SABC News, and this is how we wrap it with the entire team, Abongile Yankees, and of course, we also brought you the action from inside. I can barely hear myself speak or think at this point because it's all in the ear. But Alicia, this is where we say goodbye from East London until the 15th and 16th of April.
So much to my anchor, to SABC News anchor, as well as my colleague there, Sakina Kamwendo. She's just giving us a wrap, of course, from the aftermath of the pre-sentencing procedures in the trial, of course, in the sentencing.